Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Welcome to the Fourth Circuit. Please be seated. We'll hear our argument in our first case, the Securities and Exchange Commission versus Clark. Mr. Lisitsa, did I pronounce that correctly?
Yes. Lisitsa, either one.
All right. We'll be glad to hear from you.
So, may it please the court, David Lisitsa for the Securities and Exchange Commission. So, the legal issue in this appeal is whether the government must have direct evidence of a tip. And we know the answer to that. Courts universally have agreed the answer is no. Circumstantial evidence of a tip is sufficient. The only question for this court is whether a reasonable jury could conclude that Wright tipped his brother-in-law, Clark, about a merger. If Wright tipped Clark, then Wright breached a duty for personal benefit, Clark knew about that breach and benefit, and Clark unlawfully traded CEB options on the basis of that material non-public tip. And based on the evidence here, a jury could conclude that Wright tipped Clark. Indeed, this case has 5 main hallmarks of insider trading.
Is it crucial for your case that Wright tipped Clark as of a specific date?
Yes.
All right. What date is that?
It's crucial that Wright have tipped Clark prior to Clark first beginning trading on December 9th, 2016.
Why is that?
Well, December 9th is at some point before that point. So that's when Clark first begins trading on the merger.
Well, to follow up on Judge Agee, I mean, arguably there might be, at some point, there's evidence that Wright was brought under the tent. And I think Wright, that's, as I understand it, agreed, or there's evidence of that by the 15th of December. And after the 15th of December, you have more than circumstantial evidence, and you have Clark engaged in trading that's very different than before. A lot of the same arguments you make about the trading that begins on the 9th. Why wouldn't that be enough? And why do you have to worry about the 9th?
Well, that was the theory of the case, and it makes a lot of sense why that's the theory of the case.
Well, now, which was the theory of the case?
That the tip occurred prior to December 9th, that Wright is, even if there's that based on the change in control emails that Wright exchanges with Anschutz on November 3rd, that Wright is in fact aware of the merger long before December 9th.
Well, let me ask you a very direct question. If we were to conclude that the evidence was insufficient to find for the Rule 50 purposes here that there was a tip on or before December the 9th, do you lose?
That there was not. Is that the question?
Right.
Well, let me just explain a bit about the theory, if I can. So
that's a pretty crucial question, so you're going to need to answer that.
Right, and I will. And I think the answer is that we need to demonstrate a tip before December 9th, on or before December 9th. And the reason is that the December 9th trading, that the first trades that Clark conducts, he buys options that are expiring in January 20th. He buys 40 options at that point, 20 options that are expiring in March. And CB is trading at the time at $59.50. These options are short-term and they're at the $65 amount, so he's betting on a tremendous increase in a very short period of time. And in the event that the tip came after that, I think Clark would say, and what the district court said was, well, he's already made massive trades on the merger, and so we accept that, in different circumstances, if someone, for instance, was in the securities industry, and we see a case like Roger Rotnam, and someone is committed to trading on a certain issuer, but then they obtain, and they get analyst reports that are legitimate, but then they obtain inside information on the side. If they continue to trade, that would be our theory in the case, that it doesn't matter when that first tip was. At that point, that person becomes disabled from tipping.
But your point is, if they merely continued what they had done without a tip, you would have that would be fatal to your case.
Yes, I mean, that was how it was litigated, and I just think that we disagree with the district court about the evidence that the reasonable jury could find that Wright had this inside information prior to December 9th, and I could walk through that because that is very crucial, and we
It's important
recognize
to
that.
walk through that, but I think the reason that you're getting these questions is that there was a lot of evidence after December the 9th. And both counsel can correct me if this is wrong. My understanding of the record is that the evidence from your expert, uncontradicted, was that there was radio silence from December the 9th until whatever day in January of 2017 the merger was announced, which would seem to indicate that there could be insider trading during that period. But what I understand you to say is that if you don't show tipping by December the 9th, then the district court should be affirmed.
If there was a reasonable jury could find that there was tipping on or prior to December 9th.
Right.
I think that's the case that we have, and I think it's reasonable given the trading here. And I don't know that there's radio silence after December 9th, but I think that it's just the pattern of trading changes drastically.
No, well,
given the nature of
your own expert witness said that there was no public discussion anywhere about the possibility of this merger during that period of time.
I don't think there's any discussion about the merger, that constitutes leakage at any time, was the expert's conclusion. This merger was always non-public. When announced, it moves the price tremendously. It moves volume tremendously. The expert ran an event study that indicated there was no leakage. I think, though, it is crucial to consider the evidence about the tip prior to December 9th. So it depends.
Let's go with the theory the horse you're riding, the December 9th date. So looking at the record, it looks like you have activities in the years before where Clark would engage in put transactions, right before public accounting information was revealed. And there it seems pretty clear that Wright has inside information there. So there's no question that the tipper in those situations has the information. Fast forward to what we're talking about now, the actual evidence I guess the record talks about Wright getting information, on the trip to London. And so I guess the evidence you have is that Wright and Amschutz were close and with each other a lot, talked a lot, and you have some emails about change of control and the consequences of that. What else do you have?
Well, I think there's also the Wright's emails to employment recruiters.
Okay.
But I think it's important to talk about these change in control emails. We do think that's the strongest evidence.
Okay.
And it's Wright and Anschutz are worried about their unrestricted stock losing out on it because it's unvested. And Wright is looking for another job, and they're worried in the middle, late at night, talking about what effect will a change in control transaction have on this restricted stock. There's no other change in control transaction being, underway at CEB. In fact, merger negotiations are underway since October. On October 21st, CE Boards discusses what it calls this change in control transaction, which is a merger with Gartner, using the same language. And then on November 3rd...
Am I right that the evidence reflects that Wright was actively prospecting for other employment at that time?
Yes, and Anschutz was aware of that. And a person in these circumstances loses their options if there is a change in control transaction, was one trigger, needed a double trigger. The second trigger was leaving. So that is both triggers were involved here with these RSUs, these restricted stock units that were extremely valuable. And, that's what they're worried about. And there's no other discussion about what they're talking about. Anschutz himself says, I was referring to the event, I was referring to what was happening, and what else could it possibly be? There's no other merger on the table, and they're talking about it, and Anschutz is aware of the merger as of November 1st. That's what CEB tells as part of an internal investigation that is routinely conducted of when did people know things. So Anschutz is aware of change in control.
So help me on that issue. You say Anschutz is aware there. He says he doesn't know till Thanksgiving. But I know there's an allegation, maybe the FINRA report or something, that he may have known earlier.
Yes.
Help me with the evidence that he knew earlier. He knew at the time of these change of control emails.
Right. So the CEB conducts an investigation after FINRA notices this unusual trading, and CEB puts together, like issuers regularly do, a list of when certain employees and officers were aware of the merger. There's a separate determination made for each officer and employee, and CEB says that Wright is aware of the merger as of November 1st. That's at A969 and A983. He's also, he's the chief accounting officer.
I'm sorry, Dick.
Yes,
I know you got more, and I want you to, and I apologize, I just can't remember this right now. Is that report part of the evidence that was introduced in trial?
Absolutely.
Okay, so that's in the record?
Yes.
Okay.
As are the change of control transactions and emails to recruiters.
What was the evidence in the record that established the validity of that date?
Well, if you read, it's part of a packet. There's a whole packet of a response to FINRA that's made, and that's at A953 to 63.
Well, why don't you summarize? How did they get that date?
So basically, what you have is I think it was Kirkland and Ellis, Sullivan Cromwell, puts together, some major firm is tasked with doing an internal investigation at the firm to determine the dates of awareness for all the officers and employees.
Right, and what I'm asking, we know the date was there in the report. What I'm asking is, what's the evidence that establishes how they got there?
It's discussed in that batch that they interview people, they have emails, they talk to staff people, they conduct an email review. I think it's a sort of a routine internal investigation.
I think the question is, we got that
Right.
they interviewed people and came to that conclusion. Is there anything that you can tell us as to what was the basis of them coming to that date? Not that they did stuff, but what they found when they did that stuff.
I just think in the ordinary course, that's how these dates are determined, and there's nothing in the evidence that suggests it was different, or, he's the chief he's the chief accounting officer. Anschutz reports directly to the CFO. He's not some minor player. It's not a surprise that he is involved in merger negotiations, that are underway.
Sorry. Did someone testify as to the contents of the report? Was there a lawyer from Kirkland and Ellis or some other person that summarized the report and the evidence supporting it?
No. And I don't know that there were just exhibits about maybe certain drafts made on the other side. No, not about this report. The report itself contains its own findings and discusses how it arrived at that for each individual, and it just in broad terms, but no, there's no specific explanation of how it determined, how the internal investigation determined the date of Wright's knowledge. But again,
it was admitted?
Of course, yes, it was admitted. And again, the change in control emails show that on November 3rd, Anschutz is aware of this because he says...
He's aware of what?
He's aware of a merger negotiations with Gartner. Because he admits there's no other event or merger offer on the table. What else could, again,
I get your argument that is circumstantial evidence that he knew, and maybe that's enough there, but I don't know. Without having inside information, companies, like lots of things, people just wonder and hear stuff, and there could be just general awareness that there might be something. There's a difference. The fact that they're talking about that, I don't know, means that he knows about these offers. Your argument is it may not, but a jury could conclude that. I get that point. It seems like there's a big difference in knowing about specific offers and being in a company where, things get talked about. And
Right.
there might be some potential transaction
Right.
on the horizon.
Well, but the offer gets firmed up along the way. It's not just at November 3rd. So the first offer comes in November 7th. This is all before December 9th. Right, first offer comes in November 7th.
Doesn't that hurt you if the emails are November 3rd, that the first offer is not there until November 7th?
No, merger negotiations can be material long before there is a set price or terms to a deal. That's black letter law from Basic v. Levinson and TSC Industries.
Is there evidence that that was going on here?
Yes, and if you read the proxy statement discussing the entire course of the merger negotiations, which is at A936 to 52, that reviews some of the evidence I'm talking about. For instance, CEB is referring on October 21st to a change in control transaction with Gardner. That's October 21st. By November 3rd, you're having a change in control emails between Anschutz and Wright. I mean, that is
Counsel, can I
certainly the
ask,
strongest circumstantial evidence.
Sorry. You spent a lot of time talking about the change in control emails, and I get that. And early on in your argument, you sort of downplayed the other evidence regarding Mr. Clark's efforts to obtain other employment, and talking about the fact that he had worked on a merger in promoting his skill set. I mean, I don't, you seem to think that that wasn't very significant. I suggest otherwise. I mean, that seems to be pretty powerful evidence. What other merger could he have been talking about at that point?
That's why it's the main, it's a main piece of evidence. There are other pieces I'm happy to go through, but
And all of this is, we can all disagree as to the import and strength of the evidence, but this case was dismissed at the Rule 50 stage. I mean, it would seem clear that this was something for a jury to figure out.
I mean, that's certainly our view of the evidence and the case, that this is, a very strong insider trading case where we have concealment, we have out-of-the-money short-term call options, we have expert testimony, we have contact with an insider before the
Does the
merger is announced. I'm sorry.
Finish your answer. I apologize.
With parallel trading,
Yeah.
we have unusual financing of trades. I mean, it sort of checks all the boxes of what we would consider in our review of an excellent insider trading case. And we don't appeal all of these determinations either. Sometimes the SEC loses summary judgment and does not appeal, like in All No Holdings and in Trong. We're very careful in our review of these, of what appeal to take, and we had no answer to why this strong case was taken away from the jury, given.
Why don't you answer whatever
evidence.
question Judge Quattlebaum has? We've let you go over some, so.
I appreciate it.
Judge
Okay,
Quattlebaum.
I'll be
please.
real. We talked earlier about the post January 9th activity, and you explained why you thought December 9th was the key date. But do you agree that the evidence of Clark's trading after the 9th is part of the circumstantial evidence?
Oh, absolutely,
Okay.
absolutely.
And then wasn't there evidence that Clark, was not completely truthful about his trading in interviews?
Yes, Clark admitted.
Was
on the
that
stand.
in evidence?
Yes, that was on the trial.
Yeah.
That was on trial testimony.
Oh, that
by
was trial
Clark.
testimony? Okay,
Yeah.
all right, thank you.
Thank you very much. You've got rebuttal time left, so we'll hear from you again then. Mr. Cummings?
Thank you. And I agree that December 9th, 2016 is the critical date in this case. It's a date that the trial court below looked at, heard evidence on. One of the things that we had to deal with is a complaint that had all kinds of wild allegations saying that tips went back to 2008 when Clark started trading. And the reason why I think that historical trade that you pointed to is critical in this case is because the case law they've cited and the case law in the briefs talks about these situations where you've got somebody who's got a history of trading in that particular stock or in that particular way. And what Mr. Clark was trading on back from 08 to 2015 was the downward pressure on this company, the fact they'd had 7 or 8 acquisitions, and the stock price would be going down. What happened in the fall of...
All of those trades before 2016 were puts where he was betting on the...
All but 2.
All but, okay, the majority were those. He was betting the stock was going to go down, so he bought a put tied to serendipitously the earnings reports of the company. But then we get here in 2016, and now he's doing a lot of calls betting the price is going to go up.
What happened on November, I think 7th, Your Honor? On November 1st, there was no discussion about a merger. On November 2nd, Anschutz is not in the room. He's escorted out. The proxy statement reflects that. He's escorted out of the room with other management except for the chief executive officer, and they reject the merger. They reject the offer. So there's no evidence there's going to be a merger until November 7th when, again, behind closed doors, that a firm offer is given for the stock.
Counsel, I want to follow up on what you just said. A second ago, there was some discussion about how merger negotiations can precede offers, and of course that's true. What I'm trying to figure out here, is there evidence in this case that the merger negotiations were happening before the November 7th offer, or before the first offer?
There may have been a phone call back in August between the CEO of Gartner and the CEO of CEB, who had announced his retirement in August. There may be a phone call where there was some interest. I lost my train of thought, but those trades, there was clearly downward pressure on the market. This is somebody who watches the stock market. If you read his testimony, which is in evidence, he's got a thesis, and he explains why he did the trades he did, and he lost as much as he made. I think he was directionally correct on about 14 or 15 of his 17 trades. Now, what happens in November? He's watching the market in November. Donald Trump's elected. What happens to the stock market? It goes up this stock goes up 24%. I think it's 23 in a fraction. Unheard of in the history of CEB. Going up that much in so short a time. I think the stock market went up 2,500 points. It was wild. Clark watches this. He watches this company. He watches the market. So we're getting into December now. It's a Friday, December 9th. We're getting into the holidays. It's time for me to do something because when this guy's inaugurated, we're going to have another rally. That's what he was betting on. In fact, he corrects counsel during his testimony. These weren't merger trades. I was trading on my observation of this company, the fact we'd had the Trump bump in November, we were going to get another Trump bump, and I made a mistake. I wanted to put them out past the quarterly earnings announcements, excuse me.
So why isn't that an argument that the jury should weigh as opposed to being a Rule 50?
I'm sorry, I missed the first part.
Why isn't that part of the evidence and the argument to be weighed by the jury in the full context of all the evidence instead of on a Rule 50?
Because there's no evidence that the tipper had material non-public information on December 9th when Clark makes his trades. That's why. And that's what the court focused on. And if you read the court's reasoning, we go back and forth and they go, well, you'll hear from Mr. Wright when Mr. Cummings calls him. I waited 2 days for them to put Mr. Wright on. He hung out in the hallway for 2 days. I've never found a case cited by them where they didn't put the alleged tipper on the witness stand. So they left him off of their case, and they're saying, well, Mr. Cummings will call him and he'll clear that up. We'll get those memos they're talking about. he had explanations for those. You should look at his deposition that the judge had for the summary judgment. So the judge is aware that he has denied that any of that had anything to do with the merger. He didn't know about the merger until the 15th on his trip to London. He was emphatic about that. And he was corroborated by Anschutz. He's corroborated by the documents.
Can I ask you a question? You mentioned summary judgment. The district court denied summary judgment?
The district court denied summary
Okay, so
judgment.
what was the difference in the evidence at the trial as opposed to summary judgment? Because there were 50B is essentially a...
Well, the summary judgment, they had Wright's testimony, and Wright denied in his testimony, and had explanations for the emails he's talking about. He was getting ready to leave. He was worried about his stock being invested. That's what that was all about. But of course, they didn't put him on the stand, so we didn't get to hear that. But the judge knew that, and the judge gave them every opportunity to put their case on.
So none of the summary judgment evidence you're discussing actually came in at the trial?
Well, they didn't put Wright on the trial. And I was going to put I was going to put him on the witness stand as well as his deposition.
So none of that came in for
No,
purposes of...
I didn't get a chance to get my case on, Judge, but he was going to be my witness because he denied that he knew anything until December 15th when he was in London. And he is a lower level guy. He's not brought in on any of the merger negotiations, and the only reason they brought him in was to help with due diligence. And that testimony is clear in the record.
Did the district court, in deciding the Rule 50B motion, address at all the November 3rd exchange of emails between Wright?
It came up.
No, I'm asking you directly, did the district court address that evidence and explain why it wasn't sufficient to overcome the motion?
He didn't go into that kind of detail.
They didn't go into any detail about it.
Well, what he said was, you didn't call Wright. And didn't Mr. Anschutz establish when he came under the tent? And didn't Mr. Clark start making these trades before? And doesn't he have a history of this trading? And don't they talk to each other on the phone from time to time? They get together for Christmas and that sort of thing? He did challenge him on that. And he said, and he knows this case law because he referenced, you don't get the inference in these premises. And I argue in my brief that they don't get that. They don't get an inference. They haven't shown that Wright, by circumstantial evidence or direct evidence, that Wright knew until December 15th there was going to be a merger. And then you got to know what the stock price is going to be if your tip's going to be at all effective. So you need to know the stock price, which fluctuated. It wasn't agreed on until the afternoon of the 9th. He wasn't there. He was packing for London.
Can you tell me what the explanation is for the evidence related to your client's discussions with potential employers and the fact that he had been working on a merger? Can you explain that?
Wait a minute, my client?
Yeah. Mr. Clark?
No, you mean...
I think you mean Bill
Mr. Wright, I'm
Wright.
sorry, Mr. Wright, sorry.
Oh, well, that's easy. There was discussions about, I'm thinking about moving to Charleston, South Carolina. I want to keep the house I have here and buy the house in South Carolina. Do I have the assets to do that? What are the interest rates like? That was in mid-November, I think, that phone call. It's talked about in Mr. Clark's testimony. But that's what that was about.
I'm asking what Mr. Wright was talking about with respect to his employment prospects.
Oh, it was a company, I think it was called Benefitus, and they were looking for a CFO, if I'm not mistaken.
And my question is, what merger do you think a reasonable jury could have inferred he might have been talking about when he mentioned that he was involved in merger discussions and consummation of a merger?
That's the only one, but then he explained that was mere puffery. He was trying to get a job.
Well, that's an explanation. I get that. But why isn't a jury entitled to assess that?
Because you have no proof.
It's coming directly from him.
In a document that he explained ad nauseum. And then if you go to their admissions judge, they admit, and that's their admissions started 2,487, and they admit they don't have any evidence. They don't raise that. They admit that he didn't know until the 15th. You follow me? I'm not sure.
Go ahead. I'm listening.
So
You're saying the SEC admits that Wright didn't know until the 15th of December?
They had no direct, they admitted they had no direct evidence and no
This is a
witness.
direct evidence case, but you're saying there's no circumstantial evidence that would show that any jury could use to make a determination before December the 15th?
The two documents, they related. That's all they had. And I don't think that's sufficient circumstantial evidence to give them an inference, and that's what the judge found.
Right.
They didn't get the inference.
Which two documents are you referencing now?
The two that he talked about, the document where he asks and shoots about what happens to my unvested stock if there's a change of control. Okay, we talked about that, and we knew he was looking for a job. We talked about the FINRA document, which there is an admission that's often mistaken, and they didn't even put a FINRA person on. And then I guess the other thing would be his puffery to an employer, and I think this was after, it was in January, where he's saying, well, I helped with the merger, I helped tie it up in a bow. And he testified that that was mere puffery. But one of the things they can't get by, and what they just slough by, is, well, all these trades, he was getting tipped then, but there's no evidence at all, except one phone call, I think in 2015, that he even talked to Wright when he was doing that history of trading. And the case law talks about that. The case law says you lose the inference when you've got somebody who's been trading, especially in the stock, and you say, well, he was doing puts. But that's the type of trading he was doing. He was betting on the downward pressure in the market, 09, 08. And then in November, he saw the Trump bump where the stock went up 23%. Their own expert had to admit that. And then the anticipation, and he starts trading on the 9th and he hadn't even communicated. There's no communication.
Do those
with Mr.
cases
Wright.
that you refer to involve or have evidence that, with respect to those earlier trades, there was a relative who was an officer of the company? That's what we have here.
They all involve Sergeant Ginsburg Larrabee. They all involve people that were friends and people that knew each other. I don't know if there was a brother-in-law situation in any of those.
Okay. What are we to make about the evidence relating to the phone and your client's failure to turn over his phone?
Oh, I'm glad you raised that, Judge. In their admissions, and Clark's admissions, which starts on 8/25/10, admissions 20 to 25, no request for the phone, admit that he turned his phone over to his employer. They're doing a little switcheroo here. He had a phone that it went bad. You couldn't use the screen anymore with your finger. He turned that into his employer, right? His employer gave him a new phone. That's the phone they wanted to subpoena. So we were able to download a bunch of the text from that phone and provide it to the government. The phone they're talking about was a year later. It didn't even have any information on it relative to the 2016, early 2017 timeframe. He lost that at a theater in Tyson's Corner with a car full of kids. He laid it on the bumper, and he talks extensively about that in the testimony in the trial. That's in the appendix.
So which of those two phones did he have in November and December of 2016?
The one he turned into his employer, and the phones belonged to his employer. They did, and they also admit in the admissions, Judge, that they didn't even ask for, the FBI didn't even ask for these phones. And the SEC had subpoena power until he'd already lost it, until he'd already turned it in. So that's a red herring. That's trying to show these concealment. And then the judge even talked about that. Well, he admitted that he knew Wright within the four corners of his interview with the FBI, and the FBI agent couldn't really remember when it was. Did I use the present tense or the past tense? So that's another nothing. And Judge, if you go back and you look at the admissions, they have to admit that they're bereft of any evidence to show that Clark knew on December 9th what the stock price was going to be, or that there was going to be a merger. He was betting on the Trump bump. He's got a thesis in the, you can find his trading thesis from 673 to 776. in the appendix. Some of his orders didn't even get filed because he was going cheap. He was trying to get the things as cheap as he could. Now, is somebody with a tip going to miss that? Is somebody that's got a tip and knows what the stock price is going to miss that? And I don't know, if he had the tip, why wouldn't he have gone at $75? Because the stock price was going to be, I think, $76.25. It was even above 75. He didn't go above 70.
I guess one explanation is you don't want to make it too obvious, right?
Well, I guess so, Judge. I have to agree with that. If you're looking at him with a sinister connotation, but the fact of the matter is, the judge heard all this evidence. Was waiting for them to put right on the stand.
Let me be clear about this. I don't know what a jury would ultimately do with this case, but the question is whether or not this case should have gone to a jury to figure out. And I'm not making any judgments about that right now. I just have some concerns about the evidence that apparently the district court seemed to not properly weigh, frankly, should have not been weighing, but left it to a jury.
Well, I don't think he weighed it. This is a judge who said for 2 days of testimony, we left on we recessed on a Thursday. He had 3 days to review the record. He was aware of their request for admissions, all the admits they had to do, that they didn't have any evidence, especially the older trades. There's no evidence at all that he was tipped on the trades going from 2008 to 2015. So the case law is very strong. That's a powerful piece of evidence that keeps them from getting the inference they so badly want the judge to give them. And the judge says...
What about the Judge Hilton's conclusions as to what conclusions you could draw from Mr. Clark's interactions with the FBI? Because his conclusion was, well, that's just father lying to protect son, which could be.
Well, when you
wouldn't the jury, wouldn't it be within the universe of possible conclusions that the jury could conclude to the contrary, that Mr. Clark lied and therefore his other testimony was not credible?
It's an ancillary issue. It involved an allegation to Mr. Clark that his son was taking $48,000 or $49,000 in cash out of a bank, which presumably was a payoff to Mr. Wright, on video with Mr. Clark. None of that's true, of course, but he was baiting Mr. Clark to see what he would say. And Mr. Clark, he said, I clammed up, I shut the interview down. So I think that's an ancillary issue, Judge.
Hold up. I thought the agent asked Mr. Clark if he had disclosed any information to his son about trading, and then he later admitted that he did.
That's true.
Well, isn't that change of story something a jury would be entitled to weigh in a credibility finding?
Well, the judge ruled that it wasn't because it's an ancillary issue.
I understand that, but that kind of goes back to the central question of what the jury gets to decide and what the judge gets to decide and when they get to decide it.
I think the central question, Judge, given the case law, the law and the case law, it's pretty clear that if if Wright wasn't aware of material non-public information when Clark made his trades, and Clark has a history of trading, they don't get an inference. And I think that's what the judge found. Now, that little ancillary piece you talked about, the judge satisfied himself that wouldn't even go to the jury, probably. The judge satisfied himself that that's ancillary issue and that the jury shouldn't have had it. Please go back and look at those admissions when you get a chance. What else could I address? Because I think the case law, if you look at the case law and you look at this evidence, it's very clear, and they say it, I say it, the linchpin of this case is December 9th. And they can't show a phone call, they can't show a communication, they can't show that Mr. Wright knew what the material non-public information was. I see that my time is up. Thank you so much.
Thank you very much. Mr. Lazitza, you've got rebuttal time, so have at it.
Oh, thank you. So the more I heard my friend talk, the more I thought that that's a lot of good arguments that could be made in a closing argument to a jury, and it should have gone to a jury. It also seems to me that it's Clark's position that requires a great deal of speculation, that there has to be some change in control transaction on the table on November 3rd, but not this merger. And that Clark is a trading savant only when he trades in CEB. And that Clark lied to the FBI to conceal his trading, but for some other reason. But all of these things are explained if Clark is trading on a tip. And I don't know if there's a particular subject that the court is interested in or the panel is interested in discussing, but I thought, again, it seems like everyone is on all fours in thinking that the
Can you
crucial
talk
factor.
briefly about, your friend on the other side very emphatically pointed out that there's a plethora of cases that suggest that in circumstances such as this, that the SEC's evidence fails as a matter of law. What is it about those cases that you think are different, or why aren't they relevant to this particular set of facts?
Well, I'm not exactly sure what cases he's referring to. I think it was mostly about prior trading, perhaps.
So what about that? The prior trading, he says, it actually helps his client,
Right.
not hurts him.
So I think, the jury could see that trading as further confirmation that Wright was tipping Clark on CEB's intro information. He's got an incredible success rate, trading options only in CEB while his brother-in-law worked at the company. And a reasonable jury could attribute that success. He predicts the post-earnings direction of CEB stock 14 out of 17 times. It's an 82% success rate. It drives an amazing profit from that. And a reasonable jury could attribute it to something other than his investment acumen. Now, to be clear, there are cases where there's prior trading, and they say, well, and it makes it a tougher case when there's prior trading. But usually there's not someone who's their brother-in-law employed at that company at that time, where there's, a close relationship between the two. They live a mile apart. They fraternize, they socialize, they lunch. They have a personal and professional relationship. So a jury could really draw a liability supporting inference or a liability negating inference. We think it's more likely than not when you look at tremendous success, really only in CEB, kind of an obscure company. This is an Apple where someone just has the product and they really like it. This is an obscure company where his brother-in-law works there as controller, which is not a low-level position. This is someone in charge of internal financial reporting, GAAP compliance, external reporting. So I think that's what distinguishes those cases. And a jury could really go, we think it's more likely than not, if you look at the history of trading, that it's only in this company and he's got a pipeline into this information. But that's a question for the jury, is what we think. And then if I could, just to, again, go through the evidence about this prior to December 9th. So, October 6th, there's a strategic transaction on the table with Gartner. October 21st, CEB's board talks about a change in control, that change in control transaction. November 1st, then there's a internal investigation that says Anschutz is aware of the merger negotiation. On November 2nd, there's Gartner CEO tells his board that he's going to send a written proposal to CEB in the next few days. And you have the change in control emails on November 3rd. But that's not like the end of the story. Remember, the trades are in December. Anschutz is close to Wright. He knows he's leaving the company. They spend 400 minutes on the phone together. They have lunch every day in a weekly poker game. And between November 7th and December 9th, when Clark first starts trading, there's 6 offers to acquire at set prices. The 6th offer comes in at $77 a share on December 7th. During that November 7th to December 9th period, there's 12 text messages exchanged between Wright and Clark. There's also the landline call on December 9th. So during a time when everything's getting firm.
Counsel, just we have those text messages, don't we? Or most of them. I think there's some evidence that I think is helpful to you. Maybe it's enough, maybe it's not. But text messages and phone calls, when at least on the text messages they don't contain the information, is that really helping your case?
It does, because first of all, it shows close contact in close proximity between an insider and trading.
That's really all it does, is that two brother-in-laws text a lot.
Well, they do, but Ginsburg says that that's part of the picture. It's part of the constellation of evidence, is close proximity of communication. And also, I'm just responding to my friend who said there's no communication. When we don't have the contents of the text, but we certainly have, in the absence of such communication, we'd be standing up here and they would say, there's no evidence. They said they lived close by. But where did they realize evidence that they communicated? Well, we have that here.
Okay.
12 text messages and a phone call. And then we also have...
So why don't you try to wrap up in the next minute?
Sure. I think, merger negotiations, even the identity of the merger company, the company that's going to be acquired, is extremely sensitive, and no one doubts that. And if you look at the change in control emails between Wright and Anschutz, and then Wright's emails to employment recruiters, where he says he's working on the mergers when he first spoke to them on December 8th, and you have a district judge who doesn't even address this evidence. Our point is that we just, in this very, very strong case, that type of evidence, in addition to the concealment, parallel trading, and very suspicious trading, should go to the jury. Thank you.
Thank you very much. We appreciate the fine arguments by both counsel in this case. As you know, our normal practice would be to come to the well of the court and greet you in person, but our COVID restrictions are still in place, so we'll simply wish you the best and hope you'll be back in the future when we can resume that practice. So with that, we will move on to get ready for our next case.
Council.
Thank you.
There's two. Just use one.
So we'll now hear argument in Alberti versus the Rectors and Visitors of the University of Virginia. Ms. Royno?
Good morning, Your Honors. May it please the court. We're here today because the district court in this case forgot to apply the standard for a motion to dismiss and also imposed a standard for direct evidence on my client, Andreas Alberti, in evaluating a motion to dismiss where we were proceeding under a theory of circumstantial evidence pursuant to the McDonnell-Douglas framework. For example, in determining that the nexus between the discriminatory comments and the termination was too attenuated, the district court cited two cases, both of which the plaintiffs were pursuing a direct evidence theory. And in fact, in Finkel versus Howard County, this court specifically said that the isolated remarks were unrelated to the challenged employment decision and were therefore insufficient to provide direct evidence of discrimination. The comments that were made in this case...
Can I ask you a question?
Sure.
We're at the 12B6 stage, so what does any of this nexus McDonnell-Douglas have to do? Isn't it simply a question of assessing plausibility of the claim?
Exactly. That's exactly my point.
So why are you telling us about
Well, what I'm saying is the district court not only imported the summary judgment standard, the district court also applied a direct evidence standard and said that the comments that Mr. Carta made that were clearly showing some prejudice towards people from Switzerland were not related to the decision to terminate my client.
But just to be clear, your point is that what we're talking about here is whether or not the claims here are plausible, have been alleged and are plausible,
Yes.
right?
Yes.
Okay.
And in looking at that evidence, because the standard has been sort of become more strict in recent years for the motion to dismiss, I acknowledge, with decisions by the Supreme Court. And so even though technically we don't have to prove all the elements, sometimes judges are looking at the elements. And one of the elements is whether there's an inference of discrimination or whether there's enough evidence that it's plausible that you can develop evidence of discriminatory motive. And
So what's your best evidence that you've pled for that?
I think the best evidence is the pretext evidence that he was successfully performing his research. Pfizer was very pleased with his research work, and Mr. Carta praised his research work, but also in combination with the little window we get into the decision maker's mind when he makes all those comments about people from Switzerland, which some of them I don't even understand. But
Well, they are very strange, but, I mean, do they really go to national origin?
They do.
discrimination? I mean,
They do.
what is the fact that the Swiss don't make good vegetables or bad salads have to
Well,
do?
okay, so the best evidence on the comments, I would say, is that Carta says you didn't have a good education because schools in Switzerland don't give you a proper education. And the reason I think that's the most important is because that is related to the work that they're doing. He's a graduate research assistant, and the guy is thinking
So why is
Switzerland's-
that a national origin commentary instead of an educational merit commentary?
Because he's saying that the schools in Switzerland are bad. And he says that the Swiss people don't speak proper German. And he tells him, you don't speak proper English. Where my client does speak proper English, and that is in the complaint. He merely has a Swiss accent. That is not improper English. So if you look at all of the comments that Mr. Carta makes, you can see he has unfounded assumptions about people from Switzerland.
Perhaps this is relevant or not, but in my mind, I speak some minimal degree of French, and I've been in different schools with Swiss nationals who primarily speak German, and I find their French incomprehensible. So is that a national origin comment on my part?
I think if you add up all the other things and you are nasty to your Swiss national friends and make generalizations about them not having good schools. Says, I think you asked me what the best evidence was, and I think the thing about the schools is really the best evidence. They're saying that he's saying Swiss schools are not as good as other schools. And he's also saying that
Well, what's your second best piece of evidence?
the pretext. That the fact that he was doing phenomenally good research, that Pfizer was pleased, Carta was telling Pfizer that he's doing valuable research, he gets additional funding. It was supposed to be a 2-year project. He gets another $100,000 from Pfizer to continue the research that my client, Mr. Alberti, is doing. Everything's going really well, and then he gives him a failing grade. He passes his dissertation examination, and that same semester, he gives him an unsatisfactory grade. That is, even that allegation alone, even if you didn't have the national origin comments, this court has held in summary judgment cases that that's enough to raise an inference of discriminatory motive. This isn't even the standard here. We don't even have to raise an inference at this stage. We just want to take discovery. We didn't even get the chance to take a deposition of Mr. Carta and find out if, maybe he's going to invent another reason why he gave him an unsatisfactory grade.
Counsel, from a factual standpoint, I was wondering, there's, allegations of the grades in the spring of 19 and spring of 20 that you talk about. Were grades issued in the fall of those years?
Yes, and he did get a satisfactory grade in the falls of those years. But he got an unsatisfactory grade on the heels of really good research performance.
So is that an adverse employment action or an academic decision?
It is both. If in the complaint there is an allegation which distinguishes this case from other cases where it was determined was purely academic, there's an allegation that when Mr. Carter gives him the unsatisfactory grade, his purpose is he wants to terminate him. And the allegation is that he waits until the Pfizer project is nearly finished in order to take the step to terminate him. He knows, Carter knows that if he gets an unsatisfactory grade, that is the same as an employment termination. And so our allegation is that his intent was to terminate. And allegations are enough at this stage to create a plausible case that a jury could find that there's a discriminatory motive. And I'm emphasizing—
You have to allege
Sure.
enough to say that he got the bad grade because, I forget the professor's name, really doesn't like Swiss people.
Yes, he really thinks that Swiss people have bad schools. He doesn't like.
Well, he likes their chocolate, but he doesn't think much of their salads and vegetables.
Right, he has lots of ideas about people from Switzerland, and it doesn't matter what Mr. Alberti, who is from Switzerland, shows him. That's the essence of prejudice. He's prejudging Mr. Alberti based on his ideas about people from Switzerland. But that is all, at this point, it is just plausible. We don't have to prove it. We don't even have to present circumstantial evidence of this yet. At the motion to dismiss stage, all we need to do is make allegations in order to get to discovery and show that this is a plausible case. And there's no need even to show discriminatory statements, but we did that. We went above and beyond what's required. Our main argument, I think, going forward, if we get discovery and if we're going to trial, is going to be that he was performing his job very well. He was doing the research. He was getting praise from Pfizer. He was getting praise from Carta. So why would you get an unsatisfactory grade? And that's a question only a jury can answer, the why.
So back to this issue of the grades and the claims that you've made in this case. So you've got a Title VII claim and a Title VI claim, and why isn't it, it seems to me that your argument would seem to swallow whole the distinction between Title VII and Title VI here. Why isn't that the case?
It doesn't swallow the distinction because the allegation is that Mr. Carta's purpose in giving him the unsatisfactory grade was to terminate him. And that's paragraph 62 of the complaint, where it's alleged that once the Pfizer work, the research work was done, he took the step to terminate him by giving him the unsatisfactory grade in the spring semester of 2020. Instead
And
of—
how long was it from the bad grade to the termination of his graduate employment status?
I don't have the exact amount of time, but it's the next month. He gets the grade in June, and then July 29th, it's not instantaneous because he appealed the grade. July 29th, he gets dismissed from both. There's an exhibit attached to the complaint, which is a letter to him stating that the decision was upheld, you got the unsatisfactory grade, and now you're dismissed from both. So it is both an employment that he loses and an educational program that he loses. So it's not swallowing the difference, because in other cases, this circuit has held that if it's a purely academic decision, you can only proceed under Title VI. But here, it's a hybrid decision. Mr. Carta, we're alleging, has a motive to both end his employment and to end his educational program.
Well, you have an awful lot of cases, particularly in the higher ed area, when it comes to grades and that sort of thing, where we give a significant amount of deference to the university. Is that not the case here?
I don't think you need to give a significant amount of deference to the university because it is a hybrid decision. I think even in employment cases, there is, deference, but on a motion to dismiss, we're only looking at whether the allegations.
Well, the reason I ask that is if this was a graduate student who didn't have an employment position in exactly the same setting, there wouldn't be very many cases, I would think, in the higher ed area that would support your argument.
Well, I do think it is both a Title VII and a Title VI case. As I mentioned before, the Title VII.
Well, what strikes me is that you seem to be arguing that we would treat two people in basically the same situation academically differently because one of them also happens to have a graduate assistant job.
He doesn't just happen to have it. That is his job, and so he is.
I understand that, but the thing that troubles me about your argument is that you seem to differentiate between two people in the same situation who, for academic purposes, we would owe significant deference to the decision of the university on academics, but for the graduate student who did not have a job, they would be treated one way, but your client would be treated differently.
My client would only be treated differently with regard to his Title VII claim. With regard to his Title VI claim, you would have to apply the decisions of this circuit and the Supreme Court in Title VI cases. So for a Title VII case, on a motion to dismiss, we're only looking at the plausibility.
Well, if we upheld the university's decision academically, what case does your client have left?
Well, you
I
wouldn't.
mean, he's got to get, it seems like to me you've got to plead that and then be able to show that the academic determination was wrong and there's no deference to the university in order to get to the employment part. You can't separate the two.
The motive that Mr. Carta had in giving him the unsatisfactory grades was to terminate. That has to be looked at through the Title VII standards because it's an employment discrimination claim. For Title VI, the question of just whether ending the program is discriminatory, you look at the Title VI case law. But the fact that the vehicle to fire him was through grades doesn't mean that he is subject to the Title VI standard for his Title VII claim. So you need to apply the Title VII case law in examining whether Mr. Carta had a national origin motive to give him the grades for the purpose of terminating. And at this stage, you shouldn't even be doing that because we're not required to raise an inference. We're only required to give plausible allegations of discrimination. And we're certainly not required to show direct evidence of discrimination, which is what the court seemed to be asking for here in citing two decisions that proceeded along a direct evidence route.
Anything else you want to tell us before rebuttal?
I think, no.
All right, thank you very much, Ms.
Thank
Hensley.
Good morning. I'm here on behalf of the Rector and visitors of the University of Virginia. My name is Amy Hensley. May it please the court. The district court properly held that Mr. Alberti failed to plausibly allege a claim under Title VII and Title VI for discrimination and retaliation. Accordingly, we ask this court to affirm the court's decision. In dismissing the case at the 12B6 motion to dismiss,
Why don't you pull that microphone a little bit closer to you? There we go. Thank you.
the district court properly found that the allegations in the complaint were insufficient to plausibly state a claim for relief on its face for 3 reasons. First, Alberti failed to sufficiently allege an adverse employment action. 2, he failed to plausibly allege that he was discriminated against because of his national origin. And 3rd, he failed to plausibly allege causation to state a claim for retaliation. In taking the adverse employment action argument first, Mr. Alberti's Title VII claims fail because he did not allege an adverse employment action. An adverse employment action is a significant change in employment status, such as hiring, firing, failing to promote, reassignment of significant different responsibilities, or a decision causing a significant change in benefits. Here, Mr. Alberti's allegations do not relate to his status as a research assistant. Rather, they relate to his status as a student. He complains about unsatisfactory grades that led to his dismissal. He was dismissed by the Dean's Office of University of Virginia School of Engineering and Applied Science for 2 unsatisfactory grades. He lodges a grade appeal, which is then considered by the Graduate Studies Committee, and they uphold the grading decision. And my friend on the other side has brought the court's attention to the exhibit that was attached, and that's JA-21. And there, it does not indicate on the face, and the court can see it, that he was fired from any kind of research assistant. It says that the grading decision was made fairly in a manner consistent with the best professional judgment and expectations of the discipline. Therefore, they upheld it. So as you can see—
So when was he fired after that?
Arguably, Judge, there is no firing. It is because he could no longer be a student at UVA, he could no longer participate as a research assistant, Your Honor. Those things were related in that if you are not a student, you can no longer be a research assistant. So it is a tangential effect of not being a student at UVA any further.
Well, but your friend on the other side says that's precisely the point. You've got an academic advisor who also happens to be her client's boss, and the two seem to be inextricably intertwined in a way that suggests that maybe this was all a pretext to ultimately get him gone.
No, Your Honor, respectfully, I would disagree, and I think that the case law on that tells us that when we have these dual roles, which is specific to this scenario, where we have a research assistant who is also a graduate and student, this is a very special relationship, and when we have the dual roles in that context, Your Honor, the court says we have to look at the role, and we have to look at the alleged adverse action to see if it pertains to the student's role as a student or in the employment context. And here, when you look at the allegations, they pertain to the student's role only. It's unsatisfactory grades.
So if that's true, if you kind of switch the facts and the comments, because I know you have an argument that these comments don't sufficiently allege discrimination on the basis of national origin. But let's assume it's about race and it's just horrific racially discriminatory marks and similar facts. It just seems somewhat it seems a little tunnel vision to say that if you were able to establish or even plausibly plead discrimination in the grades, knowing that the effect of that would adversely affect employment, we're just not supposed to look at that link at all.
Well, I think that the court pointed out earlier that if we have to separate those two, otherwise the Title VI essentially swallows whole the Title VII. And Title VII is about employment, discrimination in employment. And there has to be specific allegations that relate to that relationship as an employee. And if that is lacking, Your Honor, then there is no claim under Title VII. There is no adverse employment action. There is import in the word employment action. This is not an adverse action. If we were talking about that, we would be talking about Title VI. So I think, while I understand Your Honor's argument, I think that
I'm
there
not
is...
arguing, I'm just trying to make sure I understand, how the theories go.
Yes, sir. Bad choice of words on
That's
my
okay,
part.
no worries.
But my point is that when we look at the relationship here, we look at the specific allegations, we're looking at the complaint. These allegations do not in any way go to Mr. Alberti's status as an employee. And for that reason, when you look at the case law, the Rensselaer case that we pointed out, the Stewart, when you have the court look at these cases where you get a bad grades, C's, you failed. In that context, Judge, it just doesn't meet the standard to say it's an adverse
So
employment
what
action.
I've said is right. If it's a grade-based decision, we cabinet that way. And if it's not related to the actual activities, a termination or a grade thing, the fact that it affects that is not something that we can consider for Title VII purposes.
I would agree with that, yes, sir. I think if we had a scenario where Mr. Alberti was told, you're showing up to the lab late, we don't have funding for your position anymore, so we're going to take it away. You can still be a student at UVA, where you're not going to be a research assistant, or we're going to demote you. Now you're going to be a teaching assistant, not a research assistant. That would be facts where the plaintiff might be able to say, that's specifically talking about an employment decision. And while I'm not going to say that that would be enough, that would certainly be those facts that would suggest it might be. So on that point, Your Honor, I think that this court should affirm the dismissal of the Title VII claim for that basis alone, that there is no alleged adverse employment action.
But we don't have to, do you agree with this? I mean, that issue about whether the linkage of the grades to employment, whether that's enough for Title VII purposes, is beside the point if the allegations of national origin are insufficient. Do you agree with that?
Yes, sir. I think that, and here the allegations of national origin discrimination fail, they're insufficient, and therefore Title VII and Title VI fails for that reason alone. Yes, sir. And moving now to that argument, Your Honor.
Let me ask you about the adequacy of the pleading. In Count 1, Paragraph 71, the pleading is made, defendant subjected plaintiff to adverse employment actions because of plaintiff's national origin in violation of Title VII. That appears to be all there is in article and under Count 1 related to an adverse employment action. Is that what you're saying is insufficiently pled?
I'm saying, Judge, that when you look at the allegations as a whole, the allegations, there is no allegation whatsoever in this complaint that alleges a specific adverse action as it relates to employment. Nowhere, because what you have are adverse
Paragraph
grades.
67, plaintiff received a letter from the Graduate Studies Committee, upheld the dismissal from the chemical engineering program, and termination from his position as a graduate research assistant.
That, Your Honor, is what I pointed out to the court. It's JA 21. And I think if the court looks at that letter, it does not say you are terminated from your graduate research assistant position. What it says is that the grade appeal is upheld and you are dismissed from the chemical doctoral program. So I don't see in that, when I read it, Your Honor, there's any mention of anything that would link that decision to an adverse employment decision.
So that last clause, termination from his position as a graduate research assistant, is simply inadequate from a plausibility standpoint?
Yes, sir. It's conclusory at best. I mean, we are at the 12B6, and I agree that all reasonable inferences have to be given to the plaintiff, but we have to have well-pleaded allegations to be taken as true. And so that this exhibit was attached. There was no objection to that. It's properly before the court. If that's the evidence that if that's the proof they're relying on to show that there was a firing here, it just doesn't say what respectfully they've indicated. Judge, I'm now moving into the second piece, which, as I indicated, this complaint does not plausibly allege discrimination on the basis of national origin. And for that reason alone, both of the Title VII and Title VI claims were properly dismissed. Now, Alberti argues in his brief and argues here today that the court fails to consider his circumstantial evidence. That is inaccurate. The court absolutely considered all of the evidence, all of the allegations, The court noted in a footnote, I believe it's JA 91, note 2, that this is not a case where the plaintiff was required to plead a prima facie case under McDonnell Douglas. It noted that the plaintiff said he was bringing a case under McDonnell Douglas, that he was proceeding under a circumstantial evidence theory, but what he said was you have to show a claim under the statute. And what does Title VII say? It prohibits employers from discharging or discriminating against an employee with respect to their compensation, terms, conditions, or privileges of employment because of national origin. And it is on that prong that the district court properly found that the evidence was lacking. Now, the statements that were brought up earlier about that Dr. Carta allegedly said, that is the only evidence, that is the only allegation whatsoever in this complaint that is linked to Mr. Alberti's national origin. Without those statements, there is no other fact that Mr. Alberti's national origin was of consideration here at all. And as the district court properly found, those statements were isolated, they spanned several years, weren't made contemporaneously with any of his unsatisfactory grades or his dismissal.
Well, but counsel, and they may, this isn't to say which way, all this falls, but aren't you able, the plaintiff is entitled, to point out the comments about the education and the way in the speaking of German. And I guess the other one is about the food stuff and about hunters and nationalism. Those seem to be the four comments that relate to national origin. But isn't part of the allegations not just that, but the fact that Professor Carter promoted the research that the plaintiff had done, and that Pfizer continued to fund it? So, don't we get to, or aren't we required to look not just at the maybe isolated allegations about national origin, but also the other evidence that may relate that may indicate that the plaintiff was actually doing a good job?
Yes, sir. The court was required to look at all the evidence, and they did. And it was simply insufficient in looking at all of it to plausibly allege discrimination on the basis of national origin.
Is it because, why is that? Is it because these statements just aren't really what you would call discriminatory type statements? They're about national origin,
That's a piece of it, Your Honor. Yeah. I would say, here today, my friend on the other side indicates that their most powerful evidence is about not being educated properly, and Swiss schools don't educate properly. But again, when you look at that allegation within the complaint, it's an allegation that Dr. Carter said that Mr. Alberti was not educated properly at his Swiss school. It's not an allegation, even within the complaint, that all Swiss schools are therefore deficient, and I don't, that he doesn't think any education in Switzerland would be proper. Regardless, yes, to answer your question, their evidence is, the circumstantial evidence relies on these stray comments, which have no bearing on any adverse employment action. And when you have that, their probative value, their worth, even when you're talking about direct evidence, the reason why stray comments are of little value in talking about the direct evidence test applies here as well. If they are remote, if they're not talking about the employment decision, that doesn't go out the window just now because we're talking about circumstantial evidence. The court considers those same things, and that's what the court did here. And I think that's probably why you have some sites talking about that direct evidence, because it's applicable in this circumstance. And the point is that those stray statements, in addition to these other allegations, are insufficient. When you look at those specific allegations, I think if you walk through them, it is evident that those allegations do not plausibly allege discrimination on the basis of national origin. What you have is, on some unknown date, Carta told Pfizer that Alberti was performing reasonable or valuable research. We don't know when, so that doesn't help us. 2018, Pfizer extends the research project with funding for 2 more years. He doesn't make his unsatisfactory grades until spring 2019 and spring 2020. He's dismissed June 2020. So the fact that the research gets continued before that doesn't show that there's any kind of pretext, circumstantial evidence.
Well, how do we know it's before the spring of 2018 that the research is extended? What I read.
That's in the complaint, JA 11, it says in 2018, Pfizer extended the research project for 2 years.
But how do we know that was before the spring grades in the spring of because we got, okay, spring of 19, I'm sorry.
Yes, sir, I'm sorry.
No, you're right, I'm sorry.
Right, so that happens before. And then third, he says he successfully defended his doctoral proposal exam that was initially scheduled for June 2018 and January 2019. Well, that's before he's gone through the semester. I mean, that doesn't plausibly allege that he successfully complied and met all the qualifications of his program at the end of the spring semester in 2019. And then fifth, they say, in January 2020, Carta submits the abstract and says he commits to present this stuff at a conference. Again, this is before the semester has taken place. It is speculation, frankly, that he successfully complied with the qualifications of his program based on these allegations, and therefore they do not plausibly allege that he earned satisfactory grades in the spring semesters of 2019 and 2020 and was dismissed because of national origin. Any conclusion based on that, Your Honor, respectfully, is pure speculation. And finally, Judge, I would just move quickly to my retaliation argument. Here, the court properly dismissed because they found that there was no causal nexus. And there, the court focused on the presence of close temporal relationship and said that that was just not there at this pleading stage. Now, my friend on the other side has argued in the brief that they're relying on the case of Lettieri, because it is true that causation does not have to be established only by temporal relationship, temporal proximity. But other facts that alone or in addition to temporal proximity suggest an adverse employment action occurred because of the protected activity can be enough. But the facts of Lettieri are just not instructive here. That case was about a female who complained multiple times and said she was being discriminated against on the basis of her sex. Her management people found out about that, and they scrapped their plans to immediately fire her. But you have conversations within a month or two after the complaint is made that we're going to fire her. And they changed her responsibilities 1 month after the complaint is lodged. And then 4 months after they've talked about firing her, they've essentially created a scenario where her position is redundant, and she is then fired. And so the court, in that circumstance, said, I think you have enough facts here to string this negative attitude together, and it alleges discrimination within the workplace.
So can I ask about that? So that may be a clear example of sort of bridging the gap, but why isn't the evidence that your friend on the other side points to also sufficient? I mean, she points to, a claim that Professor Carter delayed Alberti's doctoral research program and set unrealistic deadlines. Well, you know the evidence. Tell me why that isn't enough.
Because when you look at the evidence specifically, Judge.
Not evidence. We keep talking about evidence.
I'm sorry, yes. The allegations, excuse me. Alberti makes the complaint to the OEO at UVA in July 2018. So then the allegations flow is that Dr. Carter allegedly knows about that because Mr. Alberti finds a letter in his lab pertaining to some unnamed student where he says, I want to have a good working relationship. That alone, the district court did not decide on that fact, but I think, Your Honor, that alone is insufficient to plausibly allege that Dr. Carter even knew about the report to the OEO, and for that reason, he could not retaliate, because if the decision maker doesn't have knowledge, that that is the main reason why the retaliation claim must fail. But in going back to your question, here they say that he makes the report, then he says that allegedly the retaliation intensified. He also says that there was a delay because his examination was originally scheduled for June, but it was postponed. Well, June 2018 is before he ever makes the complaint to the OEO. So a postponement of an examination before Alberti contacts the OEO fails to show any nexus between protected behavior and an adverse action. That's insufficient as a matter of law because it's before the action allegedly occurs. Then he says he allegedly had unrealistic deadlines in fall 2019 and 20, which he successfully met. And finally, he just says, I have these unsatisfactory grades. When you look at these allegations, comparing it with a case like Letary, it is easy to see that those gaps have not been bridged. And it's for that reason, Your Honor, that the retaliation claims should also be dismissed.
Anything else you want to tell us very, very quickly?
No, sir. Thank you for your time.
Thank you. And Ms. Zorino, we'll hear you in rebuttal.
Thank you, Your Honors. My friend on the other side seems to have taken up the district court's mistake of applying summary judgment cases and rules and a theory of direct evidence to the complaint at issue in this case. And that's important because the standard here is important. We're not looking at evidence. We are looking at allegations, asking the court for the opportunity to develop evidence through discovery. This is all allegations that only the plaintiff has. We have not yet had the opportunity to take the deposition of Dr. Carta. That deposition could very well lead to much stronger pretext evidence than is alleged in the complaint. The standard here is just whether there's enough allegations to even waste the court's resources allowing us to complete discovery. And we think that there are. And it's very important for you to look at cases based on motions to dismiss as opposed to motions for summary judgment. For example, this court's decision that came out last year in Hood-Wilson versus the Community College of Baltimore County, the alleged discriminatory statements in that case also had no bearing on the adverse action there. The plaintiff was denied a promotion. There are no allegations that discriminatory comments were made with regard to the decision whether she should be promoted or not. The decision maker just happened to make racially discriminatory comments at other times. I also ask that the court consider that even though this is a national origin case and not a race case, the comments that were made by Mr. Carta, Dr. Carta, I apologize, are really just as insidious. He is making assumptions about people from Switzerland he says that they're nationalists and they're hunters and they don't have good salads and veggies. These prejudgments and his prejudices seem silly, but if they lead to him making an adverse decision against my client, they're not just silly. And that is what we want the opportunity to develop evidence of. Also, I think it is important that Mr. Alberti is entitled to the protections of Title VII of the Civil Rights Act. If we go with, no student who also has a job can proceed with a Title VII claim, we are depriving all students who are also employees of their Title VII protections for their jobs.
Are those different than the remedies that would be available under Title VI?
The Title VII remedies?
Yes.
Well, I'm actually not sure about that, but I do know that the standard is different for looking at the evidence. As we discussed before, there's a very deferential standard towards the assignment of grades that an academic institution gives. So I wouldn't want to just concede that students who are also employees can only bring cases under Title VI because they are entitled to the protection from discrimination in their job as well as in their educational program. And here, there are allegations in the complaint that Dr. Carter's purpose in assigning him the unsatisfactory grades is to completely get rid of him, to terminate him. There's no question in this case that Mr. Alberti was terminated from his student research assistant position. The idea that because the letter doesn't explicitly say you're terminated from your position means that he wasn't is brought up for the first time here today. There is no question, he's not there anymore, he was terminated. If the pleading is inadequate on that front, we should have been given the opportunity to amend. But the
Did you
pleading-
ask for it?
No, but the complaint does say that he was terminated. And while my friend on the other side says that that's conclusory.
Well, it's agreed. You do say it's terminated, but it's pretty sparse after that.
Well, it also says in paragraph 62 that Carter took steps at the next opportunity to have plaintiff fired. And then it goes through the whole thing about the grades. And so we are alleging that Dr. Carter's motive in giving him an unsatisfactory grade is to terminate him from both things. He wants him gone. He doesn't want to work with him anymore. He got what he needed out of him with the Pfizer research, and now he's done with him, and he wants him fired, and he wants him not to be in the program anymore. That is our allegation. It's not evidence, it's an allegation. So we need the opportunity to develop evidence of our allegations, but also to develop additional evidence. The standard on the motion to dismiss is very light for a reason, because we haven't had the opportunity to inquire into the mind of the person who made the decision. Title VII cases are very information dependent, and when a plaintiff brings a claim, the best evidence that they can get of discrimination is through the deposition of the decision maker. We didn't get that opportunity. That's all we're asking for, is the opportunity to get discovery and to be able to develop evidence of a discriminatory motive. That's why when you look.
Anything else you want to add? Very quickly.
I just want to point out that this circuit has now ruled that pretext alone can get you past summary judgment. So it doesn't, so the comments that were made, that's evidence as allegations on top of our allegations that he was performing his research satisfactorily. And so since this is no longer a pretext plus jurisdiction, I ask that you allow the plaintiff to develop evidence of pretext and reverse and remand. Thank you.
All right, we thank counsel for their arguments in this case. As you may know, our tradition is to come down and greet counsel personally, but our COVID observation doesn't permit that right now, so we hope you'll be back in the future when we can do that. Court will now take a short recess and return for the rest of our docket.
Oh, sure.
Mask on, apparently.
Yeah.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. We're ready to hear argument in our next case, O'Leary versus Trusted ID, Inc. Mr. Maxfield.
Thank you, I may please the court. This case is about the application of the South Carolina Identity Theft Protection Act, which was passed to prevent people in South Carolina from becoming identity theft victims through the compromise of their personal information. One of the primary ways it does this is through a part of the statute that is found at 3720-180 subsection 4, which makes it illegal to require a consumer to use his social security number or a portion of it containing 6 digits or more to access an internet website unless a password or unique personal identification number or other authentication device is required to access the internet website. In this case, it's undisputed, at least up until this point, that that's, and as alleged in the complaint, that's exactly what Trusted ID did. It set up a website in 2017 called Trusted ID Premier, and that was in response to the Equifax breach. Trusted ID is a subsidiary of Equifax, and the purpose of it was to comply with South Carolina's data breach notification statute, which requires people to be notified if they're a victim of identity, or excuse me, if a victim of a data breach. The website, and again, this is alleged in the complaint, required that the consumer who accesses it input his last name or her last name and 6 digits of the social security number. It didn't require any other PIN and didn't require any other authentication device. Mr. O'Leary, the plaintiff, was one of at least 5,000 people in South Carolina who input his 6 digits of his social security number to the site to access it so he could find out if he was a victim of Equifax's data breach, and he alleges that this violated the law in South Carolina. He filed suit in Richland County, South Carolina. It was removed to the district court. The defendant filed a motion to dismiss, which was based at that time on not on the statute itself, or that the conditions of the statute weren't met, because they clearly were, at least in terms of the way the case was pled, but on 3 exceptions. The district court rejected 2 of those exceptions, but found that one of them applied. And the one that they found applied was what they call the authorized service exception. And it's very short, and I'll read it. It says that this section does not apply to the opening of an account for the provision of or payment for a product or service authorized by the consumer. So the very narrow issue before this court, Your Honor, is whether that exception applies.
Let me take you to a preliminary threshold point. You seem to be uncertain in the lower court, at least for a while, on whether or not there was jurisdiction. And I'll have to say, having done this for more than a few years, I think this is the first time I've ever seen a plaintiff who questioned the jurisdiction for his own suit. So what's your point? What's your position now?
Of course. Our position is that the district court does properly have jurisdiction. It has Article 3 standing. It found that in its order, and we think that's correct, and the defendant doesn't dispute that either. But it's worth mentioning, why would we raise that issue? First of all, we filed in state court and we were moved to district court, so there was that issue. But secondly, as this court has probably seen in cases like Ramirez versus TransUnion, just very, very recently in the GoDaddy case in the 11th Circuit, it's very possible to get very, very far down the road and take up a lot of the court's recesses and the party's resources to get to a place only to be dismissed on Article 3 grounds, which can occur at any time. So if this court, we agree that the district court has standing, but that's something that...
Well, you would be the one with standing.
I apologize.
court.
Yeah, I'm sorry. The court has jurisdiction to hear it, and that we have standing to be in district court. We don't disagree with that, but we thought, and this is probably a very clumsy way of trying to raise it, but that we should probably raise it as early as possible, because we've seen, and specifically in Ramirez, where the case gets past trial, past class settlements, all the way up to a certain point, and then is sort of a lot of the work is undone because there's a finding of that subject matter or Article 3 jurisdiction doesn't exist, which of course can be raised at any time.
So counsel, if we have jurisdiction, then you move into the merits. The district court seems to interpret the exception that's, on appeal here. It reads it to mean, to say the provision of services authorized by a consumer by a consumer.
Yes, sir.
And grammatically that, seems, you may have a disagreement, but that seems to flow from just the grammar of that. So the question then, at least in the district court's mind, was what does provision of service mean? And when we interpret statutes, we generally look to 2008 when this one was interpreted to see what the ordinary meaning of that phrase provision of services was. And district court looked at some dictionaries to do that. And you then have some arguments about alternative meanings and some criticisms about that. But I didn't really see your argument as framed as to what the ordinary meaning of those words were in 2008, which I think is what I believe is what we're supposed to do. So A, tell me if I'm wrong in saying that's what we should be looking at, and B, if it's not, what's the basis for saying that was not the ordinary public meaning of that phrase at the time it was enacted?
Well, I guess to answer the first part of your question, and I do think that you are wrong with that, very respectfully,
Okay.
Because I believe that the definition that applies is under 37-2105.
So you go to the statutory definition.
I think that's the first place you look, Your
Okay.
Honor, is the statute itself.
Right.
And I think where the district court got it wrong was it looked at that and said, okay, that's part of the credits, the whole thing's part of the Consumer Protection Code,
Right.
including the Identity Theft Protection Act. I think the court looks at that and says, well, wait a minute, that's just for credit sales. But if you read 37-2105-3, which has this services decision, and actually the statute that or right above it, 37-2103, it says the following definitions apply to this title.
Yeah.
This title is Title 37. And then the definition it gives of services, which I recognize is a different word slightly than service,
Right.
but under Title II of South Carolina Code of Laws, we would probably read that as the same thing. It says services includes work, labor, or other personal services, and then privileges with respect to transportation.
Why wouldn't personal services get us right back to the same place?
I think personal services, maybe that's where you start looking at the ordinary meaning of that. And I think personal services, if you read it like the court read it, it could be anything, it could be everything. And that exception is a black hole. If that exception becomes a black hole that eats the statute at that point.
But why, the way you argued it in your brief, you seem to equate what the district court said, which was defining service or in your, maybe personal service to be use, benefit, and help, as synonymous with any website that provides information for free. And it seems to me that help me with that, because what help, use, benefit seems to connote some sort of personal benefit of an individual. It seems, at least from a language standpoint, to be that way. And you seem to be making an argument about something other than that definition. Maybe I'm misunderstanding you, so if you could help me explain.
I think that if I can try to explain it, I think that help, use, benefit is from the sort of the ordinary Webster's dictionary view of the word, if I understand correctly what the court's asking me, whereas the statute 37-1053 is much more specific. The only thing, this isn't a hotel, this isn't insurance, this isn't any of these other things that are under the statute, which again is part of the Consumer Protection Code, which is all about consumer transactions and things that are generally in commerce. So the only thing that sort of general definition could fit under, I think, is maybe personal services.
Right.
But if you read it that way, particularly with the Consumer Protection Code, which is generally read to find protection for the consumer, then that kind of an exception does sort of swallow the entire statute, because there's really nothing. You say, well, is it helpful? Sure. That could be anything. And so then the statute doesn't really have any meaning anymore. And so the other thing I would point out is that
Why do you say it swallows it? I mean, if you input this Social Security information because you want something and you get it in return for that, why isn't that a personal service?
Because I think what personal service refers to is something in a more commercial context, at least under the way that I read 37.2.1053. Again, I think that would be a very, very broad definition of personal service to include any. You would have to say that I've gone to a website, there's information on that website, and that is a personal service. There is no website that you could visit where that wouldn't be the case. And that's why we say that the exception would swallow the rule.
Counselor, you, don't worry if you're not, because this is not, this kind of maybe not that common a thing, but are you familiar with the statutory interpretation tool of corpus linguistics?
I'm probably not familiar with the tool. If it were defined, I would probably be able to answer it. I'm familiar with some other ones that I think apply here, which
It's not a canon, it's a way of doing some research to find out the ordinary meaning, so don't worry about it. It's not in the briefs, and I just was curious as to whether you had a view from that
No,
standpoint.
sir. I
If you
took
don't.
Spanish in high school, so that wouldn't.
Mr. Maxfield, before you sit down, and I hate to bring you back to the beginning of your argument.
Of course.
I still have a question about whether, this complaint actually alleges an injury in fact sufficient to warrant a finding of standing. As I understand it, the claim here is that there's a heightened risk of identity theft as a result of inputting 6 digits into this program. But, you're familiar with our Beck case where, we concluded that the theft of information similar to this standing alone is insufficient to warrant Article 3 standing. So we have that case, and I cited, I wrote it, but it could be wrong, but that's the law in this circuit. And I just have a question about why, what is it beyond this risk of identity theft that sort of elevates this case above Beck and warrants a finding of standing? For example, if I think you would concede that if the company had requested the input of 5 digits, that wouldn't be a problem. It seems pretty arbitrary then to suggest that 6 digits makes all the difference.
If I might address the last part first, 6 digits makes a very big difference because if you think of what your Social Security number is, if you have a 3-digit prefix on it that is typically geographic for people born before 2000. So if I know the first 3 of your Social Security number, if I know where you're born, I can say, like, you're born in South Carolina, you're going to have probably one of 6 combinations if you're born before 2000. And I get the last 6 from a brute force attack or any sort of an attack on a website, I've got your Social Security number. And so the reason that 6 is a number that's important is because specifically of that. Now, if you use a separate authentication device or a separate PIN, it takes that away from that danger. I haven't answered your main question about standing. My argument would be that there is a privacy right, and the court found, akin to intrusion upon seclusion, invasion of privacy, intrusion upon seclusion, that recognizes we do have a right in that. It's not the same as like the argument like under some FACTA cases where, well, something could happen in the future, or identity theft or data breach cases where this is a possibility of something happening in the future. Something has now been taken and given up by somebody that they shouldn't have had to give up.
Well, didn't that happen in Beck? Didn't that happen in Beck?
Your Honor is correct. That did happen in Beck. I believe there is a case that is from just very recently in the Fourth Circuit that's Gary versus James Farron, where it appeared that they did recognize an interest in privacy that's consistent with what the district court found here. Again, I'm not here to contest that. But those questions are very good questions because it has to be raised at some point as we move forward, and I would rather it be raised now than later, so I appreciate that. Thank you.
All right. Thank you very much.
Thank you, Your Honor.
Mr. Maxfield, you've got some rebuttal time. Mr. Parrish?
Thank you, Your Honors. Ashley Parrish on behalf of Trusted ID. in light of what we've heard this morning, what I thought would be helpful to the court is allow me to briefly address the question you posed in your order about certification. Then let me, Judge Quattlebaum, turn to the merits and explain why your questions we completely agree with. We think personal services doesn't help him, it hurts him, and this clearly is a service. The idea that there is it renders the statute meaningless. We have an easy answer to that. And then last, Judge Diaz, let me address the standing point, because we do think, particularly at this stage of proceedings, given the mischief that would occur, and in light of the Supreme Court's recent Ramirez decision, there is an easy path for this court to find standing without breaking new law. So let me start with just the certification question. I just wanted to remind the court that the way that you apply that is you take a look at the available law and you ask yourself whether it's possible to reach a reasonable answer. The language that's used in the court's cases is the available law clearly insufficient, and can we render a reasoned and principled conclusion? Oftentimes when you certify a case to the state Supreme Court, it's in the case of state common law, where it really is a question of whether there's a standard in the common law and there are no on-point decisions. Here, of course, the available law is the statute, and all you're applying is traditional tools of statutory construction. We don't think those traditional tools are difficult to apply here, and therefore we just urge you to apply them. We don't think this is a situation where you need to bother the state Supreme Court. Obviously, we don't mind going there. We'd be happy to argue with them, but you've already had now argument and full briefing. We don't think the statutory question here is difficult. You can certainly reach a reasoned and principled decision. That takes us to the merits, and I'll just address two because they reinforce each other. The question here really is, the first is he accessed the website. Then when he went to the website, he took a tool and used that tool, entered a partial social security number, and received a personal service in return. And the reason he received that personal service was to investigate whether there had been fraud. That falls within two exceptions to the statute, both B3 and B4. If you just walk through the allegations of his complaint, it's quite clear that he's alleged that there's a service. His amended complaint says that he entered the portion of his social security number, quote, in exchange for access to information possessed by trusted ID.
And the district court, I think, took your suggestion at that point and said that the plaintiff had essentially pleaded himself out of a case.
Correct. Correct. And he actually specifically, emphatically says that, alleges that trusted ID, quote, rendered services to O'Leary as, quote, necessary for the protection of his identity or property, and that we provide identity theft protection services. Now, he now says, look, we're no longer pressing those claims, but of course, when you abandon or forfeit claims, you just forfeit the legal theories, you don't forfeit the factual allegations. So, but even if you just take a look at that, it is services, and I'd point you to sort of a hypothetical, I'd point you to a case, and then just common sense. So the hypothetical is when you go to the Fourth Circuit's website, you're accessing public information. You might make the argument that's a public service. I think that's a stretch, but you're just accessing public information. If you had a tool that I could then go to on your website where I could find out whether there's been any bar complaints issued against me in the last year, and I typed in my social security, your partial social security number, and it came back with information as to, yes, you are subject to bar complaints. That would be a personal service that you are providing to me. That's what's really happening here, is we had the Trusted ID had a general website, and then you'd use the tool in order to determine whether you were somebody subject to the breach or not.
So if you had to, if the issue was about the website in general that just had general information, that might swallow it, but when you have to go the additional step to have something that has almost a personal benefit, that's where you're suggesting the difference lies?
Your Honor, that's exactly right, because the definition of service, as we point out and as the district court found, is a sort of a useful act for the benefit of someone else.
Well, the district court did that, and I'm not saying there's a difference here in 2000, using 2021 sites, and I mean, I've actually gone and back to the 2008, and there's a variety of meanings. That's one, and that's fair, but I mean, there's, maybe that's the right one. I think that's one way to look at it, but there's, I think the time period matters, and I think, determining why that one and not others matter is worth it doing.
Your Honor, so let me just make sure, I think I agree with everything you said, in the sense that I agree that for statutory interpretation purposes, you do want to look at the time period. I just don't think that in this context here of interpreting what services means, it really makes that difference. I agree with you, there are lots of definitions, but I do think that the definition I've offered you to here is consistent, and that takes me really to my case, the Ninth Circuit Ruiz case, which I recommend you take a look at. It's an almost identically worded statute, and what the court recognizes there, the Ninth Circuit, is that the statute, it's all about logging onto a website. It's not the next act of asking for information and receiving it in return. And that's the whole point, which is what this statute's designed to do. And the start is to say, as long as you are out there shopping on the internet, moving around the internet, we're not going to have social security numbers or partial social security numbers being a way to access those things. But then it's not even really a carve-out. It just says the statute shall not apply in circumstances where there's personal services services being received that are authorized by the consumer. And that's exactly what we have here, and the district court was correct about that. I would just say that if you had any question about that at all, and I know the district court felt like this would require more work, we don't think it does, you could also apply B4, which is that the question there is what was the purpose of using this service, and it was to investigate fraud. And the only argument that the other side raises is he says, well, Trusted ID wasn't investigating fraud, but there's nothing in the statutory language, if you look at the literal language, that makes a difference as to who it is. What it's talking about is the act. And so here's what's happened is that there is a service that is being provided for us to allow Mr. O'Leary to investigate whether he was subject to the data breach. That clearly falls within the broad literal language of both B3 and B4. And we think that's all the court needs to do in order to resolve this case. I'd love to answer any more questions that you might have about that. Otherwise, I'll just turn to the standing question, if that would be helpful. So on standing, Your Honors, I think the way to look at this is a couple of things. First, I would start off by reminding the court, and I know there's no debate about this, but there was no 12B1 motion that was filed here, which changes things at the pleading stage. So it was a 12B6. Both sides agreed that there was standing, and both sides recognize that what that means is that they can allege general allegations and then inferences in their favor. Now, Judge Diaz, I completely agree with you. You have to do more than that, but I think the TransUnion Ramirez case is very important, and I'd also make the point that it's different from some of these other similar cases that aren't quite the same. And the reason is that in many of these cases, so you take a look at the Jeffries case in the DC Circuit, which talks about intangible harms, often that relates to things like credit cards, where the question is, what is the common law right? And there's a debate as to whether that's a breach of confidence or not. What's unusual about the Social Security context is that Social Security numbers have been recognized to be something that everyone has a privacy interest in, and therefore there's a privacy right, and this court has recognized that as well in other contexts. And the Ramirez case specifically says that when you're taking a look at those types of actions that are permissible for Congress because to create a statutory right, and that there's a presumed intangible harm because they match a cause of action you could bring at common law. Justice Kavanaugh, in his majority opinion, specifically says disclosure of privacy information falls within that category. So what we would say to the court is that this case is quite easy to resolve because you say this is a privacy interest, he's alleged an invasion of privacy. And if you had any question about that at all, I'd also point out that although he's alleging that there are penalties in 1,000 and 3,000, he also alleges in his complaint that each class member suffered $100 of actual damages. Well, there's no statutory penalty for $100, so he's pleading actual damages of $100. He would tell you again that that relates to his other claims that he's now dropped. But again, it underscores the point that he thinks that there's an invasion of his privacy here worth at least $100.
Can I ask, sorry to interrupt you, but so as I understand, the process in this case is the plaintiff voluntarily inputted this information in order to get some assurance that his credit was okay. And so in that sense, it's not the same thing as someone taking information from another. And in reading Ramirez, the focus seemed to be on the dissemination of that admittedly private information, Social Security numbers, although 6 digits, not the complete number, to a third party. So how is that happening here?
So, Your Honor, the way we would put it, and I know I'm walking a fine line here, but it's between the difference between establishing standing of a really meritless claim. And so the thing is, his theory, as we understand it, is that by having to input the Social Security number, something that he held private, his privacy interest was injured because he was further exposed to the risk of disclosure. And that's why we cite you to the D.C. Circuit Jeffries decision, where it says, looking at that type of intangible harm. Now, of course, that's in the context of a credit card, but it's the risk that your privacy information will be further disclosed. That's a sufficient harm.
Didn't the Supreme Court in Ramirez make a distinction between credit reports that have been disseminated to a third party and those that were just sitting in the agency's files, and said that's akin to someone writing a defamatory letter, putting it in a box and never disclosing it? It seems to me that's what we have here.
I don't think that's the same because of the nature of his allegations. I would also just urge the court to look at the problem that we have here that's driving this, which is that we have a case that was properly removed to federal court based on CAFA because he's alleging significant damages based on the penalties. And then he comes to the court and he's not willing to say that he hasn't suffered injury. He says he has suffered an injury. We all agree on that. But what he wants to do is have the court then go ahead and remand it so he can then proceed in state court and resurrect the claims that he's now dropped, on the theory that when we're back in state court, we can now no longer litigate this case in federal court. And what I'm worried about, Your Honor, is that this creates a strange loophole. And so in a situation like this, where there is a privacy interest and you can draw the path to say that there's been a harm here and he's alleged a harm and he's alleged $100 concrete injury, and it fits within the intangible. Judge Diaz, if this was a more serious case and you were writing some published opinion that tried to really apply Ramirez in a significant way, there are a lot of issues about Ramirez and how it gets applied. In subsequent cases, we recognize that. We just don't think this is the case to apply it. We think there is a path for the court to say they're standing and to put this case to an end, because it really is clearly meritless and it's barred by the statute.
But counsel, you may be accurately describing the practical effect of a decision that there's not standing. I'm not quarreling with that, but that really shouldn't be the basis of what we decide. I mean, we got a constitutional obligation. Our courts are limited jurisdiction. So, I think either you have it or you don't. And to say if we don't, that puts us in a bad spot may be true. We may even have some sympathy for that, but that's kind of beside the point, right?
I guess I agree, Your Honor, that we either have it or we don't. What I'm saying is we have it, and I think that there are other ways of looking at the case where you can spin off more difficult situations, and then you can say, we can come into hypotheticals. Judge Diaz, my point to you is that I realize there's that language in the Supreme Court's decision. I don't think it changes the thrust of the opinion or this court's cases that say when you're talking about a privacy interest, not in a situation where you're talking about disclosure, but you're talking specifically about a privacy interest, that we have it. And that's what I'm saying, is that the Social Security number, there's both the idea that there's a privacy interest and there's a private interest in not disclosing it. He's alleged that there's a risk of further disclosure, and that's sufficient under the case.
So help me with our Beck decision. In that case, as I recall, it was medical information that was at risk of being disclosed, which is pretty private, I think. And we said that the mere fact that a laptop computer had been stolen without an actual showing of the risk of disclosure wasn't enough to warrant Article 3 standing. Why is that case different than this one?
So I think, Your Honor, this gets us back to the D.C. Circuit's Jeffries case, and it's a question of whether you believe that by implementing the statute, when the court is focused, so in Jeffries, the D.C. Circuit says, look, the Congress has recognized here that the risk of disclosure it creates is that there will be a further disclosure. And Congress, in that sense, unlike in the context of just medical disclosure, it has created an added right here, and that right is not only to be protected against disclosure, but the further risk. And so what it does...
That's a bare statutory right. You need something more than that, right?
Well, Your Honor, the way I read the decisions is what you need first to have the statutory right in the context of Congress has recognized the ability to sue. then you need to tie it back to a common law cause of action that allows you to say that there would actually be harm. But then after that, you have to go back to the statute again and say, what exactly was it that Congress did? What was, not only was the history, so the first analysis under the case law is look at the history, was there a history? But then second, what specifically did Congress do? What the DC Circuit does in the Jeffries case is it says when we look at the specific statute, it goes beyond just the idea that there's a protection for your privacy right, but it goes further and says we want to protect you from the risk. Because there doesn't have to be a perfect match between what happened at common law and what happens at the statute, the court says that's enough to allow you to go forward with a lawsuit. And there are, we acknowledge there's a split in that DC Circuit, but we don't think the court needs to resolve that split. We think the court can follow the DC Circuit's logic here, because what's happened is that it's clear, and let me put another way to think about this, is that is there really a case or controversy? That's the first step of all of the standing analysis between the parties. And when a party has alleged in his complaint that there's $100 of damages that he has suffered as a result of the invasion, or every class member has suffered as an invasion of the privacy because of the further risk that was added to following the Jeffries line of decision, we think that's sufficient.
One last thing on the merits. Can you have a service, can you provide a service when you're obligated to provide the information? You have as I understand it, a legal obligation to notify or inform someone about whether that there's been some breach. If that's the case, can you still be providing a service?
So, Your Honor, I'm really glad that you asked that, because I made a note when he said that in his opening remarks. That is just not the case. This service was provided not consistent with our obligations under the data breach. That notice was provided through notice publication in each of those individual cases. This was an additional service that was provided, and one of the key things that you can see from the district court's opinion in the briefing below is that we had no obligation to him. What we were doing is we were trying to address a situation where many people might not know, despite...
Trusted ID had no obligation, as opposed perhaps to Equifax.
Well, I would say that Trusted ID had no obligation, but I also say that Equifax is obligated.
Well, they're the party, so that would be the relevant one.
I totally agree, Your Honor. All I would say, though, is this was not a mechanism. The reason why your question is correct is because not only is it Trusted ID is a different party, but also Equifax fulfilled that obligation in many different ways. This was not part of fulfilling that obligation. There's no connection where some court said, okay, Trusted ID will now do this for you. This was purely provided by Trusted ID to help people out, and that's why it really was a service. Your Honor, it looks like my time is only up. Unless you have other questions, I'll just urge the court that this case is not a difficult case. It fits within the plain language of the statute. I know you've had questions about standing. We think we've offered the court a path to resolving that. And we also think on the certification question, because you can resolve this by just interpreting the statute, this isn't the type of case that you would usually certify to the Supreme Court.
Thank you very much.
Thank you very much.
Mr. Maxfield, you have some rebuttal time.
Thank you, Your Honor. Let me first address something that my friend said about this sort of, I guess, being a minimal case or something to that effect. One of the things I want to point out is that the district court's made its ruling based on an exception that I'm going to return to in a second. That doesn't mean that what happened in the first place with this website being created that required South Carolina residents to put in their last name and 6 digits in their social security number with no other authentication and no other PIN number is any less reckless. That is exactly the conduct that the statute says, don't do this. And there's a reason that they say that. And so I would first of all point that out. The second thing that I would point out is that we're looking at the exception, the one that the court did apply, and we look at that and we say that it is the section doesn't apply to the opening of an account or the provision of or payment for a product or service authorized by a consumer. We've talked a lot about what's a service, but it's a two-part test. It also has to be an authorized service. And what the district court found for authorization was the very act that Mr. O'Leary had put his social security number into the website in the first place. And if
So
that's
why isn't that sufficient?
because if you read the statute that way, then there can never be a violation of it, because anybody who's harmed by what the statute's designed to prevent immediately loses their cause of action by consenting to it. I mean, that would be a nonsensical interpretation of the statute. There's another Latin canon that I probably can't pronounce and don't remember, but it goes something along the lines of, so that the statute shall survive. And to interpret this exception that way and say that anytime somebody goes to one of these, let's just say, for the sake of argument, violative websites and puts their information in, as soon as they do that, they have no claim because they just authorized it. And by the way, everything's...
Well, he authorized it because he wanted to get some information, and if he didn't want to get it, he didn't have to put his number in.
But then there would be no violation of the statute that would be before the court right now. I mean, there would be no point in having a penalty part of the statute because nobody could ever be aggrieved by it. He wouldn't have any personal standing to sue.
Well, isn't that the reason you would think that the legislature put this particular exception in there? I mean, if a person decides that this thing or service is of value to them, then they've made that decision and they're willing to forego their privacy right to the extent of the information that's returned to them.
I mean, if the court reads the statute that way, that act of putting a social security number into a website that otherwise violates the statute, then that would be the correct interpretation of that. I don't think that's what the statute intends. There's no way the statute would have any practical significance in an important issue otherwise if that were the interpretation. The other thing that I would like to move on to, and of course there were 3 exceptions that were raised, and I think they can argue all of them at this stage. I don't think they can argue that we haven't made a prima facie case for violation of the statute based on what we've alleged in the complaint. But I do want to turn briefly to this fraud exception, because what it actually says is that this section does not apply to the collection, use, or release of a social security number to investigate or prevent fraud, and then it goes on to talk about some other things. Well, Mr. O'Leary's not the implication is that this statute applies to what Mr. O'Leary is himself doing in his own investigation. I mean, he's not collecting his own social security number. He already has that. He's not using, as the statute would require, his social security number to investigate fraud. He's allowing somebody else to collect it to do that. And what I would say is that at the pleading stage, what they're actually doing or not doing is way, way, way beyond where we are at the pleading stage. We don't know the answer to that at this time. Discovery might reveal that. The Ruiz case, which was mentioned, was a case that was decided on summary judgment, and it was a very different case than this case for a number of reasons. One of them has
how is it not the case that Mr. O'Leary is investigating fraud through the breach of the Equifax database? I mean, he's seeking information about whether someone. It seems to me that very allegation is that he's seeking information to find out if someone has wrongfully obtained private information about them. How is that not the investigation of fraud?
Because that horse has already left the barn.
What horse has left the barn?
Because the fraud, all this tool is returning is, have you been breached or have you not been breached? And
Which,
that's already
if it's
happened.
true, is fraudulent. And he's trying to figure out if he's been the victim of that, right?
He is asking to be told whether he's the victim of that, whether he's included in this data breach. But the investigation of fraud, the fraud's happened in 2017 already. There's not.
So
That's already
because there's already been a determination that there was fraud, I guess that's your point. Your point is there's already been a determination of fraud, so that him inquiring as to whether he's been a victim of it isn't covered by that? Is that what I'm saying?
As a district court found, Your Honor, he's just being told the result. That's what he's getting. There's not an investigation. It's just here's what happened in the past. That's
Okay.
what the district court found. I've got 39 seconds
Absolutely.
left. So what I'll say with that little bit of time is that all of these exceptions are the same as affirmative defenses, and the defendant bears the burden of proving those under this court's decision and other decisions in other places, specifically here, Goodman versus Praxair. And on the very last thing I'll say, on the suggestion that we've pleaded ourselves out of court, this is a complaint where first of all, the mention of services doesn't occur until page 8 of the complaint. There's just the use of the word services in a negligence claim, and specifically that claim incorporates the allegations above it, but the claim that we rely on here doesn't incorporate any of the allegations of the negligence claim, and we've specifically pled those in the alternative. At this stage of the proceedings, not only must the complaint be viewed in the light most favorable to the plaintiff, but all of the inferences must be viewed in the light most favorable to the plaintiff. And that's what we feel that the district court has done here, is that it's looked at things and made inferences from parts of the complaint that are unfavorable to the plaintiff, and that's not proper at this stage. So what we would ask is that the court affirm standing, or confirm standing rather, but reverse the district court's dismissal of the case. Thank you, Your Honor.
All right, thank you very much. We thank both counsel for their arguments today. As you know, our tradition is to come to the well of the court and greet you in person, which our COVID restrictions don't let us do right now, so we hope you'll come back in the future when we can do that. And with that, we'll change counsel and be ready to hear argument in our next case. So while counsel is changing, we'll take this opportunity to welcome the students from New Kent, Virginia. We hope you'll find today's proceedings interesting and educational. Good, thank you.
Bye. Thanks.
Thank you.
Mr. Winthrop, we're ready to hear from you.
Thank you, Your Honor.
Oh, I didn't call the case, United States versus Ebert. So now we're ready to hear from you.
May it please the court. My client, William Ebert, was denied a fair trial when the government introduced salacious but non-child pornographic evidence to prove him guilty of producing and possessing child pornographic material in violation of federal statutes. The government relied on two theories to have this evidence admitted over objection. Both theories were incorrectly applied to this case. To the extent that the evidence was probative under 404B, the prejudicial effect greatly outweighed the probative value. To the extent that the evidence was intrinsic, the facts belie the fact that this evidence was intrinsically intertwined in the case at hand. The crux of this case is that my client was originally charged in a superseding bill of indictment with 3 counts. The second count, which he was found guilty of, was production of pornographic material. The third count was possession. He was found not guilty of the first count, which was taking a child across state lines for an improper sexual purpose. Prior to the trial, the government filed a 404B notice. In the 404B notice, the government wanted to prove and present evidence of numerous extrinsic matters. One of the matters that they wanted to introduce were 2 videos of victim number 1, who was the daughter of my client, engaging in non-pornographic material when she was of the age of 18 or older. What's critical about this is in these particular videos, there is evidence that when the videos were shot, the defendant was seen in a reflection and his voice was heard, and he was allegedly directing what transpired. In this particular case, the alleged victim's sister was present in one of these. Why this matters is these acts were not any evidence of criminal activity. The child was not naked. The child was wearing clothing. There was nothing illegal about what the court and what the jury heard when this evidence was presented.
But counsel, so I will divide the 404B evidence between HH, I think victim number one,
And ZN.
and ZN, because you may have a better argument for one than the other. But at least as to HH, the point is, as alleged by the government, that video, whether or not it's criminal in nature, shows that your client did this type of video. And there were videos in place before the victim was 18. So it shows the methodology. It shows he did that type of thing, and that makes it intrinsic. So number one, why is that not proper under 404B? I mean, I agree you got to be careful here. We have law on that, and if in answering that, if you could also, if it was improper, and why is it not harmless?
Okay, so to address the intrinsic argument first, the government takes the position that this was grooming, that what they were doing, that what my client was allegedly doing was initially, when the child was 13, 14, 15, he may have been taking photographs of her. Some were pornographic, many were not. I think there were only 2 series of photographs that were allegedly at some point pornographic for child purposes, and I believe the child may have been 16 or 17 at the time. But for the purpose of grooming, the child's now over age, and the child's still wearing clothes. This doesn't go to the grooming aspect. This is something totally innocent. It may be creepy, as I say in my brief, but it's not a criminal to say that because he may have been the person that took the pictures or the video in 2018, he would have been the person that took the video before. That's getting to 404A character propensity evidence. As far as 404B,
Why is that? I mean, why is it not the methodology is the evidence of what he did in a way that may have been non-criminal, not related extrinsically to the methodology of the videos and photographs that were done allegedly in a criminal way?
well, even though the allegation was he took these videos, it's different only because he wasn't taking videos of her then. Her sister was involved. This activity was more garden variety, 3 people or 2 people just engaged in normal type photographs. It may be a little bit different, but what they're trying to say is because he did something, it may be in poor taste at age 18 or 19, he would have been the methodology, as you might say, but it's a different methodology.
So isn't that almost always a line of reasoning when you have the intrinsic evidence? I mean, it's a trail of common or similar acts, and it seems like here that, wait a minute, that the only difference here is that the daughter happened to have turned 18 for this last grouping.
But the difference is for the subsequent videos, that wasn't a criminal act at all, and to say because he took videos of the daughter and with the other sister, one of them, the fact that he was doing something legal there doesn't show that it's grooming, that this is a carry forward from what he may have done before. What he was doing before was of a legal nature, and it was of a different nature. At some point, the government's allegation was he was taking pictures of her in the nude state. He was not doing that here. It had changed nature. It's the nature and the character. That's the distinction.
So if the daughter had been nude in these particular ones, you would say that that was sufficient?
If the child were nude and there was not another sister.
She wouldn't have been a child in the later ones. She would have been an adult.
In the later one, she would have been an adult. That's correct. But they don't have those videos.
Right, but what I'm asking is if the daughter, as she turned 18 in these videos, was in the same degree of lack of clothing that she was in the other one, would you have said that your 404B argument was no more?
Well, that would go more towards the intrinsic. I would argue for 404B. I see the argument, and I would say there's a distinction.
I'm just asking the question.
Yes, I see the distinction, and I would agree that what happened in the later photographs or videos was of a different nature and character and doesn't go to the methodology. I think your other question was, would it be harmless?
Yeah, I mean, let's assume hypothetically we agree with you on the the videos of HH after she turned 18 and about the evidence related to ZN. I mean, don't you still have the testimony of the testimonial evidence that was there? I think 8 photographs before the age of 18. Why is that not enough to make a video at least of someone who's clothed harmless?
Because in the other videos, it was only the word of HH as to who may have taken the photos. Remember that HH had a tattoo on her arm, which was of the father's password.
Yeah.
That there's evidence that the subsequent evidence is what was critical to the government because they could show the defendant's voice and reflection. They did not have that evidence in the other photographs.
They had testimony. And maybe this added, kind of sealed that aspect of it, but they had testimony, right? And was there any real evidence that he wasn't the one who did the stuff before? I mean, was there? I mean, I get it that he didn't testify as though he hadn't conceded it, but I mean, there wasn't any really argument to the contrary, was there?
Well,
or certainly evidence to the contrary.
The evidence was that certainly HH testified that he was the one that took the photographs. That was all of the evidence that they had as far as that went. Why it's critical is, remember, she testified also that he engaged in the acts that were the nature of count 1.
And they got it from him, right? I mean, they got the photographs that might not have had him in them or his voice in them from him.
From a computer in the house that I believe the testimony was other people in the house had access to, and HH herself had the tattoo of the password on her. I think that was the testimony.
Okay.
Then we get to the testimony of ZN. ZN also, there was no evidence of any child pornography concerning her testimony. What they had was some creepy conversations that may have occurred between my client and ZN. There was some discussions of some untoward conduct, but again, none of that rose to the level of 404B. It was highly prejudicial to allow that in because it didn't go to the pornography. It went to other bad acts that he may have been engaged in under 404A. And even if it was 404B, when the jury would hear all of the different things that were in the Skype messages and her testimony about booby potions and whatnot, the jury could take that and consider that to be the issue and not necessarily the issue that the government had to prove.
Were there limiting instructions given here?
But if you read the limiting instructions...
Well, first answer, were there limiting instructions?
There were limiting instructions. There were. But I believe the way the limiting instruction went, the court instructed or engaged in other acts or committed other acts. I think that was the terminology that the court used.
Were there objections to the limiting instructions?
I do not know that counsel objected to that limiting instruction. But when you hear that limiting instruction, the jury would certainly consider that something had to be wrong if it was a committed act. And there was nothing illegal, certainly not comfortable, but not illegal about what ZN was doing or in part what HH was doing. I only have 2 minutes. I would certainly assert that there was a probable cause issue. We certainly objected to that. We believe it was certainly stale, that when the Officer Anderson, presented his affidavit, he tried to freshen up his stale argument with just some generic boilerplate information, but we would contend that was insufficient for a magistrate to find that there was probable cause.
So the government responds by saying, even if we assume that to be true, the good faith exception would save the warrant, and you don't really address that in your papers.
We don't. We address it in the form of it was freshened evidence and that no reasonable magistrate would consider that there was such a boilerplate, bare bones allegation. But no, it was not specifically addressed. But if you look at the actual affidavit, as for probable cause, there were 60-some paragraphs. Only 5 or 6 paragraphs even dealt with this particular defendant. I believe 1 paragraph actually dealt with the allegation of the pornography, and it doesn't specify as to when this took place. It was anywhere from 5 to 8 years before it was taken out, or it doesn't even specify that you could have found this on what particular computer or at this particular location. So certainly we would argue that there was a good faith exception, well, there was not a good faith exception.
All right, anything else you want to tell us before your rebuttal comes up?
Yes, sir.
All right, thank you very much, Mr. Winthrop. Ms. Ray, we're glad to hear from you.
Thank you, Your Honor. May it please the court, Amy Ray for the United States. I guess I'll begin just very briefly where Mr. Winthrop left off with the probable cause argument. The district court did find that the good faith exception applied either way, and the defendant has not challenged that in his opening brief, so that's waived. Additionally, I would say that this court's decision in Bosick really responds very well to the argument that the suggestion that because an agent relies on what we know about child pornography offenses and has a significant amount of language in the affidavit about child pornography offenses, the collectors tend to retain those, not even collectors, even more to the point in this case, a producer who produced child pornography of his own daughter, that's the kind of evidence that someone would keep and retain.
Can I ask a question about that? So does that effectively read staleness out of any case involving child pornography collection and/or production?
It makes it very difficult, Your Honor. And in fact, in this court's decision in Bosick, this court referred and sort of cited positively the Seventh Circuit's decision in Sevier, which says essentially in cases involving a computer, staleness is almost never an issue. I'm not going to suggest that there's not an outer limit to that, but I would say that 5 years doesn't come close to it. And the Seventh Circuit's decision in Carroll involved a 5-year delay, and they affirmed that that information was not stale in a child pornography case. The Tenth Circuit's decision in Riccardi, I think, was maybe Carroll was 4 years, and I think Riccardi was 5 years with a receipt. So when you have the kind of evidence that is retained, it's not contraband, it's not smoked up, it's not used, then it requires a much lengthier period of time. And I think this court's decision in Bosick really supports that. Turning to the evidentiary issue, if Your Honors don't have any further questions about the Fourth Amendment issue, I'll move to the evidentiary issues that the defendant raises. The district court admitted both the videos of HH and the testimony and chats by ZN under two independent reasons, right? First is intrinsic. The second was under 404B as evidence of identity preparation and plan. To answer Judge Agee's question, there were three limiting instructions given, and those were on pages 135, 177, and 255 of the joint appendix. Two of those limiting instructions were given immediately after the admission on the one case of the HH videos, and in the other case, and the admission and the overruling of the objection with respect to ZN's testimony. And they specifically, Judge Whitney said, I'm admitting these evidence as intrinsic. I believe it's inextricably intertwined, and for evidence of intent, preparation, and planning. And so the district court didn't simply say something about other acts. It was pretty specific limiting instructions. On the merits of it, you know, the videos of HH depict that relationship, and it depicts the crime that Mr. Ebert committed as it was finally and fully revealed. That is to say, a young woman at 18 years old who would look at her father and smile and pose suggestively when he asked her to. And that was the result of 7 years at that point of grooming. And so that is inextricably intertwined, because not only it shows the result of what happens when you take a child beginning at the age of 11 and you instruct her to masturbate in front of a camera and do other, finally leading up to the 17-year-old, at least 8 photographs of the sexually explicit. So that's intertwined because it is the fruition of the crime. It completes the story. And this court in Byers recognized that although some evidence may be prejudicial, under 404B, it's not overly prejudicial if the evidence is less inflammatory or prejudicial than other evidence that was admitted. And these videos were certainly not more prejudicial than the photographs that the jury saw. With respect to, so that's the intrinsic evidence on the HH videos. 404B, those videos had a reflection of him that you could see Mr. Ebert in the video and his voice. So it was not arbitrary or irrational for the court to conclude that those videos were evidence of Mr. Ebert's identity and also his plan preparation. Turning to the evidence related to ZN, those also were inextricably intertwined, and the reason is HH testified, and this is sort of both why it's inextricably intertwined and why it's harmless. HH testified about her chats with ZN, and she testified at some length. I would refer the court to 246, 259, 264, 308 of the joint appendix. She talked about how she talked with her dad about his conversations with ZN. And of course, he instructed her to, or actually gave her photographs of naked women and said, go show these to ZN. By the way, take my return address off of this email. Don't just forward it so that you can see who's sending, that I sent these to you. So that's evidence that he knew what he was doing. But the other commonalities there were, he discussed challenges. He talked to HH from a very young age and offered her challenges related to her sexual activity. He says the same thing to ZN. ZN testifies that he described what he wanted her to do as challenges. In both cases, he talked about
I'm sorry, Counselor, but the thing about the completion of the story, and particularly when you get to ZN, is that it's not just that it completes the story, because you can say that in all candor in lots of situations. I think our more recent law says it has to be essential to the completion of the story. And I'm really, the HH, it seems like a different situation. The ZN, I don't think, it relates, there's some commonality to be sure, but it doesn't seem essential in any way to the completion of the story. And if that's allowed, I'm just worried about, where are the limiting principles there? It seems like now, I'm not sure, even if it's improper, that it's not harmless in this particular case, but that seems like a much tougher argument.
Your Honor, I appreciate that the argument is harder with respect to ZN than it is I believe, with respect to the HH videos. But it's also not just the completion of the story, but it's inextricably intertwined. And that's why I was saying, HH herself testifies it, because she's testifying about the conversations that her dad had with her about his engagement with HH, and with ZN, and he's asking her to engage in a sexual relationship with ZN. So it's inextricably intertwined. Certainly, however, it is also harmless. And it's harmless because we have HH's testimony at length talking about the same relationship with ZN, talking about the fact that her dad told HH and admitted that he had talked with ZN about masturbation and engaging in sexual activity with HH. And so it's harmless because it simply is, in some ways, it's repetitive of what HH has testified to. Additionally,
Were there objections to that testimony?
No, not to HH's testimony, no, about that relationship. There was not an objection. The other thing I want to note, because I think that and my brief probably didn't do the best job about highlighting this, there was additional information, or evidence rather, that Mr. Ebert was the one who did it. It didn't all depend on HH. Michael Ebert testified that after HH made her allegations, he had a conversation with his father. His father admitted having taken pictures of HH nude and said they were tasteful nudes. So that wasn't a huge part of our case, but I would just say that our case didn't hinge only on HH and those photographs. We did have other evidence that supported it. And in any event, we had overwhelming evidence outside of ZN's testimony or the chats involving ZN that supported Mr. Ebert's guilt. Mr. Ebert has made, Mr. Winthrop, on behalf of Mr. Ebert, has also made a sentencing argument related to the 5-level enhancement under 4B1.5. I would simply note that that enhancement is appropriate as long as the defendant engaged in 2 instances of production of child pornography, and our brief kind of goes through the steps as to why that's the case. We have, in addition to those 6 or 8 rather, multiple photographs of her when she was 17, nude, explicitly just focusing on her genitalia. We also have the evidence that at the age of 13, he asked her to film herself masturbating on his web camera, and that also would be the second set of instances. I don't think that that's acknowledged in the opening brief. Mr. Ebert's brief just focuses on those 17-year-old photographs. So that would be the pattern, and there are other instances in our brief that we cite to support that increase. If your honors don't have any further questions, the United States requests that this court affirm the judgment of the district court. Thank you.
Thank you very much, Ms. Ray. Mr. Winthrop, we've got some rebuttal time. If I could get you to start with the sentencing enhancement. Reading the argument you made in your brief on that, the enhancement was under 4B1.5, but the brief seems to talk more about 2G2.2. So my question is whether or not you've briefed the correct guideline.
Your Honor, I think I put the wrong statute in when I was talking about this argument. I believe that.
But you agree that the enhancement is under 4B1.5?
I do.
Okay.
But I would also argue under 4B1.5 that it requires a pattern of behavior, and I don't know, there was one video set of the 8 photographs, and there was some other alleged activity. I don't know that it requires that. But, Your Honor, I do want to address what Ms. Ray had to say concerning ZN and your questions to her. In our brief, what we argued was we have a cumulative effect of the 404B or intrinsic evidence for HH and for ZN. So we talk about both the HH evidence, the ZN evidence, and then the combined cumulative effect. And what we would contend is cumulatively, when the jury hears the extrinsic or intrinsic evidence of ZN, that together with the evidence of when the child was 18 for 404B, or whether it's intrinsic, once again, we get to the point that this evidence becomes cumulative, and that's not really evidence of what actually occurred with the direct allegations of what what the defendant was charged with. So we would say, based on all of the evidence, if you consider the probative value, the prejudicial effect under 403, we're asking the court to overturn the conviction and to give my client a new trial.
All right, thank you very much. I want to express my appreciation on behalf of the panel to both counsel for their arguments. And to you in particular, Mr. Winthrop, I see you are court-appointed. The court could not discharge its duties in these cases if we didn't have members of the bar like you who would step up and undertake them, and the court expresses its appreciation for that. As you probably have seen in our earlier cases, our COVID restrictions prevent us from coming down and greeting counsel in person, so we hope you'll return on another occasion when we can do that. And with that, I'll ask the clerk to adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.